We're live. Let's see this. Hold on one second. We are live. You may hear some noise upstairs. There are kids up there who seem to be trying on ski boots. They're optimistic and think we might actually get out to go skiing this winter. Good evening, everybody. I hope everyone's doing well. Let me see if we are all live in the comment section. So Fed Up says, Bienvenue, Viva Fry. Bonne soirée, bienvenue à tout le monde. Okay. This is going to be a relatively dense election update live stream. There's going to be some non-election stuff. We're going to talk about the McMichaels situation and maybe get an update also in Kyle Rittenhouse. But this is going to be elections update, where things stand, what's going on. There are so many lawsuits flying, and we're hearing things in the media that I think people are not able to digest just because the way I think of it is it's like having food jammed down your throat so quickly that you have no idea what you're actually tasting. And you say, oh, did you enjoy the gummy bears? It's like, I have no idea. You just jammed down so many things. I didn't know what I was eating at any given point in time. There is so much stuff going on that it's impossible to follow, even for people like Robert and I. I think Robert has an easier time, but for me, I'm trying to follow this stuff and know what is what when we're talking about what. Incidentally, let me just start off by saying I have been told by YouTube that I am legally required to notify everyone every 15 minutes. The Associated Press has declared that President-elect Joe Biden has won the election. With that said, these are the items on the menu for tonight. We have that Michigan lawsuit, which was not a Trump lawsuit, and its dismissal. We've got Trump's Pennsylvania lawsuit. We've got L. Lynn Wood's Georgia election lawsuit. And we're going to talk about all of this. A few of the standard intro disclaimers. Nothing in this is legal advice, but that's going to be less applicable. Super chats, thanking you in advance for all the super chats. If I can't get to the question, you will forgive me in advance. If you're going to be angry that we don't get to your super chat question, don't do it. I don't like feeling guilty, but we thank you for the super chats. The warning, YouTube takes 30% of super chats. If you have issue with that, and I know a lot of people do, Robert Barnes and I have a locals page, which is vivabarneslaw.locals.com, where you can get some exclusive content. We interact regularly there, and I think locals takes 10%, which is better. Plus, it's a good platform, a good community. Second thing, the only discussion that I may have to flag in the comment section. Spam bots, so those Russian sex bots, and I know when you come into the stream because it becomes obvious, those get reported and removed. Keep it civil, keep it respectful, and above all else, no tongue-in-cheek jokes about violence because it's not funny at this time, if ever. Just be respectful and be courteous to this channel and to what Robert and I stand for. The discussion, it'll be heated. You can swear and you can call each other names. No jokes of violence, not even tongue-in-cheek. I was watching Tim Pool do his stream with AJ. I don't know if that name is still verboten on YouTube. And I liked the way he was respectfully reminding AJ to keep the discussion, to that would not result in the stream being taken down. And it's still, he had a problem. So let's do that. Now, tons of super chats, and I see Robert. Let me just see if I can get to some of these before we get started. Real Bambuga says, Viva. That 15-minute thing was a joke, right? Yes, it was a joke. Associated Press has warned that President-elect Biden has won the election. All suggestions to the contrary, that there should be any court contestations, shall be stricken from the record. Looking good. Oh, by the way, it's something. I feel cranky. I feel tired. I feel pale. I feel stressed. And you want to know how crazy it is? I've actually started having dreams, like consistent dreams about this. I dreamt about Tim Pool. I had a dream with Donald Trump. I had a dream with AJ. I had a dream about the politics. I had a dream about the elections. Haven't had a dream about Sidney Powell yet, but the week is young. Joe Biden is not the certified president-elect of the USA. This is going to be the first thing we're going to talk about with Robert, just to remind everybody what the constitutional process is behind all of this. Not to start a fight, not to poke fun at the media for declaring it, just to let people know what the actual constitutional process is. And then we're going to get into some serious lawsuits. And I see Robert, and he's looking good as always. He's on his laptop. So we'll see if this is smoother. Cleopatra. And my answer is the press cannot call who the president is. Sorry, this is on YouTube. we're going to get into it. You're 100% right. And most people don't appreciate what the certification process is as provided for in the Constitution. And it's just an interesting dynamic that we're seeing in the media right now. What do we got here? Did you see Daily Mail report that Biden Foundation gave no money to cancer research? I did not see that. Thank you for the super chat. Viva Fry. I've had dreams about your performance. Okay. And that's the double TMI of the TMIs of the Uber TMIs. Now, I missed a bunch here. Jeez Louise. The Georgia runoff. Going to be intense. I mean, that's going to be something to follow from a political perspective and from a legal perspective, because a lot of legal questions are going to come up as to domicile, whether or not people can be told or move to Georgia in order to vote. Crazy stuff. Now, I missed one. Oh, is it right here? P. Patrick Carey says Ted Cruz talked to Trump. His advice was to get better lawyers. Well, you know what? Perfect segue. Speaking of better lawyers, I'm biased, but I'm bringing him in. Robert, how you doing?
Yeah, can you hear me?
I can hear you. You're good.
All right. Hey, all right. Hey, it works. What do you know? I don't have the suit on tonight because I'm on the road, and so I've been on the road since really almost since the last show. I was on an early flight. A particular person asked me to come to Georgia, so I've been in Georgia since then.
Okay. And now, incidentally, there are things I'm not even going to ask Robert certain things that I don't know if he's not even able to disclose. And if I do ask a question that I shouldn't, I know Robert's got the better discretion to not answer. So there's some stuff that obviously Robert, if he has non-public information, cannot disclose. But to that extent, Robert is following this and can help us with the legal questions regardless. So let's start with the first question here. And just we've discussed it in previous vlogs, previous streams, but just remind everybody and walk everybody through what the actual process is from election day to projections to the Electoral College, how they are certified and how they are awarded, the time frame for that, just to explain to people that the way we're seeing it being presented right now may differ from the constitutional procedure.
No doubt. So the Constitution delegates to the state legislatures the means by which they choose electors who form the Electoral College, and who meet on a set date and cast their votes for the presidency of the United States. So the state legislatures can choose how those electors are picked within their state. When the Constitution was first passed, it was anticipated that the Electoral College would actually act as kind of a little r Republican check on pure democracy. And some states, in fact, did not delegate that to their voters. But many voters wanted to be able to have direct election of electors. So for most of our history, most states have had whoever was qualified to vote on a set day. And the Constitution does say a set day. It hasn't always been that way, unfortunately. But and they're supposed to do it on a select day. And that date is usually the first Tuesday in November, historically. And what happens is the state legislature determines here's how we're going to pick our electors, gives it to in almost all the states, well, all the states now, and including some territories, the District of Columbia included. They allow that the people to vote on it, the qualified voters. And based on various Supreme Court decisions over the years, there are certain limitations on how they can do that. So, for example, a decision came in that said that you can't have a durational requirement for voting for the presidency more than 30 days. So that's why most states have that you can register to vote for the presidency up till 30 days prior to the election. Some states have actually allowed you to register on the same day. And there's been different registration requirements depending on the state, but they cannot require it to be more than 30 days. So then people vote, and the vote is counted. And there's a part of the voting process that's supposed to take place in each state is you have a canvassing of the vote. The canvassing of the vote includes looking at the absentee ballots, making sure in most states the signatures match or whatever, or some have witnessing requirements for counting the ballot. And then they count the ballots. Some do it by a computer machine. Some do it, well, I don't know if anybody does it manually anymore, at least not initially, and that's the count. So you have the canvass and then the count. And then depending on the how close the election is and the individual state's laws, you can have a recanvass, you can have a recount. The recount can be either by machine or manually by hand. And you have something that's called a risk limiting audit. And I'll get into more of that a little bit down the road.
Actually, if I can stop you there.
Yeah.
I mean, it oversimplified. What's the difference between a canvass and an audit?
So an audit's supposed to basically capture everything. So usually everything that involves the entire voting process. So to take people back, we've had multiple contested presidential elections. 1824, famously, Andrew Jackson had the election stolen from him. In his view, he did win most electoral votes and most popular votes, but it went to the House, and the House ended up giving it to someone else based on a compromise deal that was reached. Then the next time was 1876. And in 1876, what Congress did is they decided to create a commission to decide the contested electoral votes. Because what happened is in 4 different states, they sent different sets of electors. So there was a contest as to who was actually the representative electors of those states. And enough of those states formed a majority. They formed a commission of 10 members of Congress and 5 justices. And ultimately, it came down to an 8-7 vote, and they gave it to Hayes. There was a backroom deal cut where the Democrats agreed to allow Hayes to be elected president as long as Hayes agreed that once he was president, he would withdraw federal troops from the South, which in turn took away, civil rights protection, frankly, for people in the South for the next 90 years. Then, not long after that, Congress passed a law to govern how they would handle future election contests concerning presidential electors. And the question has always been whether that law is binding on a newly elected Congress. Even liberal organizations like Lawfare have opined just recently, in the last month or so, that that law is likely not binding on a newly elected Congress because it's the Constitution that delegates certain power to Congress. So, but that law sets up a provision whereby if there's a dispute as to electors, a member of the House and the member of the Senate have to join in an objection. Each chamber comes back and declares what they deal with that objection. There's serious problems with the law because the law appears to suggest the Senate has a role in determining who the electors are when the Constitution delegated that role explicitly to the House of Representatives. But so the certification process works as follows. Under the election law that they passed after the Hayes case, after 1876, basically empowers the executive of each state, which is effectively the governor, to make a independent determination as to certification, as to who his state has chosen for the electors to be part of the Electoral College.
Is there a party behind you, Robert?
I think there is. Oh, yes, there most assuredly is. So sorry if there's a excess. Somebody, that's the first time there's been a party here the whole time I've been here.
It adds to the ambiance.
Yes. No doubt about it. So you can imagine the Constitution dancing to the tune behind us. So the net effect of it is supposed to be that the executive of each state certifies who his state chose as electors. In most states, they rely upon the Secretary of State first to certify who the state picked for electors pursuant to the state process. In almost all states, there is a way to contest an election. There's some that are specific to presidential elections. There's some that are not. There's some states that have no election contest process. So you really have almost 50 different rules in 50 different states. In order to deal with that situation, Congress passed a law that said, okay, if you have a contest proceeding in your state, then we're going to safe harbor that to allow you to have that fully adjudicated and determined. And as long as the outcome of that certification contest process is decided at least 6 days prior to when the Electoral College meets, you have what's called a safe harbor. Your electors will be included within the Electoral College. And so this year, I believe that date is December 8th, because I believe December 14th is the date the Electoral College actually meets. And the Electoral College votes, and then what happens is that then it goes to Congress. The president of the Senate, usually the vice president, effectively opens up and says, here's who the Electoral College says has a majority of electoral votes, or goes through them. That's where a member of the Senate, member of the House can object. They can have 2 hours to have a hearing on it and come back and decide whether they sustain the objection or not. Again, there's a question about whether the Senate is usurping a role that belongs to the House, but that's a question that's never been decided.
And actually, if I could stop you there, when you say a contestation just means that that just means literally that the candidate does not concede. Does it mean that they have to raise specific issues, or do they just refuse to concede and therefore make them go to a vote?
It depends on each individual state. So the way the election contest proceeding works is in most states, well, I shouldn't say most states, it actually wildly varies, but you have somebody you appeal to. You say, I contest the outcome of this election. And this happens usually at a non-presidential level. So you'll see these election contest litigation brought, for a state house candidate, town council candidate, sometimes a United States senator in the 2008 case in Minnesota between Al Franken and Norm Coleman. And in some states, it's a judicial process where you file an election contest. And what the norm is you have to show there's enough votes that are in doubt to place the outcome of the election in doubt. So, for example, in Bush v. Gore, there was multiple tracks of litigation, but Al Gore filed a election contest. And in most election contests that are judicial, it has to go to the county where the state capital is. Because technically what happens is the Secretary of State, in that case, certified the election. He filed, usually the certification is the trigger for an election contest. He filed it and he said, here, there's a bunch of votes that are outstanding that have not been counted that are more than the margin of victory. In other cases, it's, there's some degree of votes that have been cast that are in doubt because maybe they're absentee ballots that were improperly processed. Maybe they're provisional ballots that haven't been correctly counted, or maybe there's some other controversy or issue present.
And now, in order to affect the outcome, or in order to affect the integrity of the outcome, do you have to prove that there's enough contestation of votes that would change the result, or that might just show that that process itself was compromised?
It's really there too. It's a bifurcated process, and it depends also on the state. So in most states, you have to show one of two things. You have to either show there's enough votes in doubt that are greater than the margin of victory. You don't often have to show that those votes would have gone for you. It's just votes that show that the margin of victory is in doubt. Or you have to show what's called systemic irregularity. And so much systemic irregularity that it's the kind of irregularity that you can't prove which way the ballots, that there's a bunch of votes that you could never know one way or the other because it's so systemic. Okay. So, and all the states have had different arguments about how to interpret the law. Election contests are relatively rare, but sufficiently common over time that we have a fair amount of case law over the last 125 years or so well, I shouldn't say most, but in enough states that we have some manageable standards that are supposed to be utilized. But that election contest process is supposed to be resolved prior to the safe harbor date. So what happened, for example, in Bush v. Gore challenged it, contested it, wanted certain votes counted in certain counties that had not yet been under his interpretation. Trial court judge wouldn't go along with all of what he was requesting. So it went up to the Court of Appeals. The Florida Court of Appeals said, we don't want anything to deal with this. We're going to kick it up to the Florida Supreme Court. They did. The Florida Supreme Court, as I recall, had 6 democratically appointed judges, 1 Republican, if I recall correctly. They ruled, yes, we're going to count these ballots, and they have to be counted as part of the certification process, and there has to be an amendment of the certification, depending on what happens. That went up to the United States Supreme Court. And that was the famous Bush v. Gore decision. And what the U.S. Supreme Court ruled is that the standards were so standardless, they lacked uniformity, that equal votes were not being treated equally, and that violated the Equal Protection Clause. And because there was no manageable recount that could take place within a sufficient time frame prior to the safe harbor date, they canceled. They said the recount cannot go forward. And that is how that decision was finally adjudicated.
Robert, I'm going to ask you one thing. Can you put it on mute for 1 second?
Yeah. Let me see here.
And do you think, is there a place where you can get quieter in your apartment where you're staying? Someone raised a good point that we don't want to get incidentally caught by some claim of music in the background. So while Robert does that, we're going to see. Hopefully, we can find a good room. Let's see what he says here. He's going to bring it back.
Apparently, I somehow triggered this automatic thing that's in this Airbnb. So leave it to me to figure out a technological way to make this interesting.
Well, though, you know what? At least the party was a more interesting explanation. Okay, that's good. Now we can get back to regular. Now I'm getting totally paranoid that I just got an email about the music. Okay, I didn't. We're good. I don't think that was enough to trigger any algorithms on YouTube.
Oh, right.
It has been turned down. Okay. So we're on the certification process. Let me ask one question. I know a lot of people are asking: has there in recent memory, like, has there been a certificate? Has there been a case where the state legislature has not granted the Electoral College votes the way the vote of the state went?
You could argue that took place in 1876 because there were different bodies certifying votes, and they were contesting with one another who won the actual state. I think there were 4 states actually contested, and that was because of what was being submitted from those states. And but that's the last time it's happened. 1876 is the last time it occurred, and they passed that Election Reform Act legislation not long thereafter, and it's been the governing law ever since. Now, like I said, there's questions about whether that can be binding on a future Congress, given the constitutional delegation to the House, really, for these kind of determinations. But that's an open question.
Okay, so as it stands now, is there a formal process that Trump has to do? Is it something he has to sign in order to formally contest, or is the absence of concession a formal contestation?
No, it depends on the jurisdiction. It depends on the state. Some states have no election contest proceedings. They're basically, you could try to sue maybe under federal law because there are equal protection issues. What happened in Bush v. Gore is that there was parallel track litigation. So while there was litigation contesting the election by Gore under the Florida's election contest laws in Leon County and Tallahassee, at the same time, the Bush campaign had sued in federal court, alleging that the way this was being conducted violated equal protection principles. That went up to the 11th Circuit. The 11th Circuit decided to hear the case en banc, where all of the judges issued a ruling. Now, they ultimately did not grant the injunctive relief, but there were several dissenting judges who laid out why they thought it should. Of note, they laid out the very argument that Scalia would then adapt to get a majority of the U.S. Supreme Court to say no further that it violated equal protection the way this recount was being conducted. So there's multiple remedies as a candidate. It depends on the state. Some states you get an automatic recount. In some states you can request what's called a risk limiting audit, and in other you can request a recanvass, and that it varies by jurisdiction. Sometimes you can get it automatically. Sometimes people may remember Jill Stein paid for them in 2016 because some states require you to pay large sums of money for a recount. Some states did not allow a recount in 2016, like Pennsylvania, even though Jill Stein sued in part on issues related to issues that are occurring now about technology. Well, what happens when we have computers counting ballots? Can things go AWOL? Can we have confidence in them? People on both the left and the right have been raising questions about this since 2000, that a manual recount is more trustworthy, even with the risk of human error, than is having computers involved when people don't know whether those computers can be manipulated in some manner, when the software or the hardware is designed by people outside of government who may have some conflict of interest of some type. And of course, various hackers and computer technical experts have been showing for 2 decades now that these methods of counting ballots are insecure. So that's the issue. But essentially, as a candidate, so let's say there's an election, they report initially whatever their initial count is. One of the first things you can do is you can say, I want to recount, and sometimes the law allows it, sometimes it doesn't.
It has to be within a certain margin of error, I would imagine. That's less than 1%.
All depends on the state. Some states, a real small margin gives you a right to request it, and some states, a real small margin leads to an automatic recount. It also depends on the state as to whether that's a manual recount or a computer recount. For example, in Georgia, you're entitled to a automatic recount. It's not clear whether it's manual or technical under the law once it's within a certain margin. Now, in almost every state, the Secretary of State has the inherent authority to order a recanvassing or recount. And this goes back to a variety of election reforms that were passed after the 2000 election. Congress passed a bill in 2002 that created the United States Election Assistance Commission. And its goal was to write sort of best practices guidelines for, how do you do a canvass? How do you do a count? What kind of audit? They're the ones who came up with the term risk limiting audits. How do you check to make sure that all the processes worked correctly after an election? How do you do a recount? How do you do a recanvass? And all of those, and it gave recommended protocols and procedures, laid it out over many years, and they updated that over the years, and really provides excellent guidelines. In addition, there is a Blue Ribbon Commission formed by the Election Integrity Project out of Minnesota, brought secretaries of state experts together back in 2014 and in part they were inspired because of what happened in the Minnesota recount in 2008 that ended up being pretty controversial because of how they counted or did not count absentee ballots in particular. And they also established they wrote a book and a guideline called Best Practices for Recounts and Recanvassing. And so we have excellent guideposts and guidelines out there. And a lot of states, pursuant to the United States Election Assistance Commission, creating templated laws, sort of your uniform laws for risk limiting audits, have adopted that legislation. Unfortunately, so far, almost no state is implementing the recommended procedures there, which I think is unfortunate because to give people an idea, the goal of an audit is to make sure everything that happened in the election process was correct. So you check the machines, you check the software, you check you recount the vote, usually manual recount the vote if it's close enough. You make sure there are observers present who can challenge and contest it, monitors present who have a partisan motivation. You have Democrat and Republican present, for example, or whoever the candidates may be, representatives present, so they can see the whole process. Part of recanvassing is you bring out all the absentee ballots, the absentee ballot applications, the absentee ballot envelopes, how they match or do not match, and you do a signature match check in front of observers so everybody can feel comfortable and confident in the outcome. That was the point of risk limiting audits that a lot of state legislatures passed. The only state that so far has tried any part of that is Georgia. And even there, unfortunately, it appears they have not implemented most of the recommended protocols and procedures for that. And so we have a process in place that is intended, that's been built over the last 20 years in terms of risk limiting audits and recanvassing and recounting. And of course, we have a constitution that's been in place for 200 plus years to deal with these issues in general, to have the political branches ultimately make a decision. People know when they vote for the House, they're giving them power. Part of the constitutional power they give them is to decide contested issues about a presidential election. And unfortunately, there appears to be a great effort to have neither of those remedies put into place. And I've been trying to argue publicly and in other manners, but particularly what I've done publicly is, we can have confidence in this election if we just utilize the protocols and procedures we've come up with over the last 20 years and employ the constitutional remedies our founders created. And everybody can feel good about the outcome, or at least as good as they're going to feel. Unfortunately, there's an extraordinary effort by the media and unfortunately by a lot of secretaries of state to not do that and to rush to a conclusion and to make the Associated Press replace Congress for who determines the presidency of the United States. And
now this is just to highlight it. It's not a semantics game where you say president-elect is the formal term once the Electoral College votes are cast in favor of Biden. It's a requirement. So right now it has become custom over the last, I don't know, however many decades, that when it becomes clear enough or there's a concession, then I guess the word is colloquially or informally, we can refer to the victor as the president-elect until such time as the votes are formally given by the legislature. In the event of a contestation, that doesn't happen. And it's going to be the state legislatures that are going to determine and resolve those contestations such that it's not just potentially premature, but potentially setting an expectation that people might be very disappointed about if, for whatever the reason, they do not, the outcome is not what was predetermined or pre-declared once they meet on the 14th.
Yeah, I mean, exactly. I mean, especially the first part of this process, which we've created all these wonderful guidelines for, is let's make sure the vote is accurate and as transparent in the voting process as possible. So let's make sure we have a recanvassing. Let's make sure the signature match was properly instituted. Let's make sure any provisional ballots were accurately counted. And then let's make sure the count itself with a manual hand recount with observers present is properly done. So they can make sure that do simple things like part of an audit process is make sure there's not more votes than voters. That you match how many voters voted in the precinct according to who was listed in the rolls compared to the number of votes cast. It appears already in Georgia that there are some ballot boxes that have fewer ballots than was reported as being there. So That's part of the process. And not only that, these are not only the standards that have been adopted by our recommended officials of both parties. President Jimmy Carter, the former president from Georgia, last Georgian to be president, also recommended these kind of protocols, and to be particularly careful with absentee ballots because of the risk they present. The same was true of Democratic Party and Republican Party litigants over time, but it's also true of our international standards. It's what we, the United States, require before we will certify or recognize an election in a foreign nation. We require these protocols and procedures to be in place. So how is it we're not going to impose on ourselves the same process we demand of foreign governments and foreign countries? It makes us look bad. It makes the whole process look bad. And those who are sort of pushing for a concession, that's not going to satiate the concerns of many people who don't know if the vote is an accurate vote of lawful ballots cast. And it's not that hard to do this.
Well, that's the question. It's setting aside what might be the media incentive to do this. And I've got theories, but theories and opinions are not necessarily what these streams are about. The question I was about to ask, in Georgia right now, what's the state of the affairs there? It's a hand recount. Is that part of a limited audit? Is that part of a canvass, or is that part of a formal other procedure?
So what the Secretary of State publicly stated was that he was going to do all three at once, an audit, a recanvass, and a recount as part of their risk limiting audit protocols and procedures, which was within his inherent discretion to order prior to his office certifying the election. Unfortunately, it does not appear that is what has in fact occurred. So what is in fact, hold on a second.
This is what I believe is referred to as boomer moments based on the comment section. Okay, we'll let Robert come back in. This is going to be one heck of a podcast for anybody listening to it, only the audio and not actually knowing what on earth is going on. But
yeah, exactly. I mean, they were talking about thoroughbred horses. I have no idea how anything I said triggered thoroughbred horses. Maybe there's some folks listening in who did that. I'll leave that to people's imagination. So yeah, I mean, there's a protocol and procedure here that he publicly announced he was going to do. Which I was very glad to see. And I was hopeful that Georgia would be the example for the rest of the country in these contested states where it's very, very close. Let's use these great procedures and protocols that we've produced with experts and bipartisan consensus over 20 years to instill confidence in the outcome, whichever outcome that may be. I mean, for people who don't know, I've been part of election litigation almost 20 years. And have been pushing for this for often independent third-party candidates, but also for whenever it's a contested race. Let's use something that everybody can say, I feel confident in this outcome, even if they don't like who the winner may be declared to be. And so he initially announced that. He said in his public statements, you can look it up in CBS and elsewhere, he said, I'm going to do all three, a recount, a recanvass, and an audit as part of his risk-limiting audit process. And that's a manual recount of all the ballots. In Georgia. Now, in Georgia, ballots were cast in two ways, either a handwritten ballot sent in by mail, or if you went and voted in person, it was done by a machine that printed out a ballot and you put the ballot in. And so as part of this, wanted to make sure that, I hope to see that the number of votes matched the number of voters, make sure there was no, unusual duplicates or anything like that taking place, that the vote count was correct, the machine didn't overcount something or undercount something. Also wanted to make sure the signature check was actually enforced, because all across the country, there has been even though we had a historically unprecedented number of mail-in ballots, 5 to 6 times the norm, sometimes even 10 times what has been previously done in a state or county, we're seeing a rejection rate that is historically low, that is 10 to 20 times below the norm. So maybe it's the case that all these ballots don't have a single problem with them, and that the signature check would be fine. But the best way to do that is to have an independent observer monitor the signature check, see it. Okay, there's the voter registration signature, there's the election signature. My understanding is a lot of these states have digitized these records, so it's not that complicated. I mean, it could be time consuming, but not terribly time consuming, given the nature and the consequence of this election. But it appears that none of the counties are doing that in Georgia. So in fact, it appears that's not happening anywhere in the country. It appears that the singular request that could really resolve a lot of concerns is the very request that they are refusing to grant any county, anywhere in the country.
And just so people appreciate this, is that there was, I don't know how many times more mail-in ballots this election than in previous elections for obvious reasons. And apparently, the rejection rate of the mail-in ballots now was something like 10 times lower than in every other previous election where there had been 10 times less mail-in ballots. And the question is why? Now, the question of cross-checking the signatures on the ballot to the signature cards, I think there might be some confusion here. I have a bit of confusion. I've been reading that there's a signature on the envelope and a signature on the ballot, but that wouldn't make any sense in terms of cross-checking because that would be one and the same element. There's a signature card that all mail-in ballots have to be cross-checked with, in theory.
Yeah, so what it is almost all the voter registration files have they usually have multiple signatures on file for you. So, for example, they usually have your driver's license signature on file. You have a lot of motor voter states. They called it motor voter because when you got your driver's license, you were automatically registered to vote in some states. So they'll usually have your registration, they'll have your voter registration. When you registered, if you registered separately, they'll have that signature on file. They'll usually have your driver's license signature on file. Sometimes they'll have other signatures on file, such as when you may have requested an absentee ballot application, you may have signed the application. They may have that signature on file. So they usually have multiple signatures on file, and people can look it up. The state of Colorado, the Secretary of State's office, put out a very practical guidance for how you can interpret the signatures, only 20 pages long. Anybody can learn it in about an hour. And most of us have practical experience with this. I mean, the signatures matter. Signatures should matter as much in your vote to match as it is if someone was trying to draw money on your bank account that had your signature on a check if it wasn't your signature. So bank tellers do this every single day. So this is not some kind of like crazy esoteric science. It's a pretty basic thing, and they do it. I have a lot of experience doing it, representing clients who submit petitions to get on the ballot or a referendum to add to the ballot in those states where that's allowed, or initiative. And there they have applied signature requirements basically every election cycle because there's someone that's trying to get on the ballot or there's an initiative or referendum effort afoot in most states in the country. And the election officials are very accustomed to checking signatures. Now, I can tell you that signature check rate usually results in about a 20% rate of the signature not matching the signature on file. They have always been much more liberal and generous when it comes to absentee ballots, which I always found a little peculiar. It's like, why is it just trying to get on the ballot? Your signature match has to be strictly enforced. But when it's an actual ballot, somehow the standard should be far less. I never understood that. But putting that aside, the norm has been at least 2 to 3% of absentee ballots are rejected for not matching signatures. And as the number of people dramatically increase that do absentee balloting, the concern of fraud and other issues has led to things like in New York and New Jersey, when they increase the number of ballots, absentee ballots, the signature problems increased, not declined. And in fact, people can look it up. There's a New York Times article in 2012, which went into great detail about the great risks associated with absentee balloting, especially as it increased, because it has always been, in the last 100 years, the number one source of election fraud. And in part, that's because when you go and vote in person, you are in a safe, secure location. You can cast your ballot in secret with no coercion or fraud. And you are usually checked in some manner. In Georgia, you have to show your photo identification. In other states, they have other methods of checking you. Maybe your date of birth, maybe your address, maybe something else. But you have to do it physically there in person. People observe you doing it. And so the risk that your ballot is coerced or is fraudulent or is purchased or anything else is substantially reduced. So just that risk by itself created risk with absentee balloting. That risk is not even addressed really by the signature match. The signature match just makes sure you're the one who actually filled in that ballot. And the concern is that with lots of ballots flying around and being sent out everywhere, you had basically a bunch of blank checks. And you don't want people cashing that check who weren't the authorized person.
Yeah.
But it appears that there was a lot of litigation in the summer and in some in 2019 in a bunch of states that was meant to discourage secretaries of state from actually enforcing the signature match, even though the legislatures passed no laws amending that. And there's something called the Electors Clause, and that just goes back to the state legislature determines the rules for the presidential election, and it can't be determined outside of court, outside of the legislature by, say, a private agreement between a secretary of state and some other people.
This is the perfect segue. Now I'm going to remember the minute. 40 minutes. L. Linwood filed a lawsuit in Georgia, and it basically, I'll summarize my understanding of the proceedings because it does refer back to this settlement agreement between private actors and the government. So L. Linwood's lawsuit, essentially, if I'm not mistaken, it's a 14th Amendment lawsuit. The essential allegations are that Georgia had set out a procedure for mail-in voting. There was a lawsuit, I forget who it was, but it was a Democratic Party that had sued the government, and the government entered into a settlement agreement, which they call the transaction or whatever, whereby the verification of the signatures on the ballots in the event that there was an issue would be subject to some sort of panel verification of not one poll ballot counter person, but rather three. And this deviated from the legislative rules governing how to resolve an issue with the signature on the ballot. This was a private settlement agreement entered into between, I forget what it was, the Georgia Democratic Party and the government, which otherwise altered the legislation as to how to do it. So the basis of the lawsuit that L. Linwood has filed now, it is basically not treating votes equally, I think, as the base constitutional question, enjoining certification of Georgia's Electoral College votes until they remedy the issue. And what else was there in terms of the conclusions? I think I got the essence of it, really. It's the bottom line is that there was a private settlement agreement entered into subsequent to a litigation that altered the law as relates to verifying signatures on the ballots, and might explain why it was basically, from what I understand, virtually none of the signatures were invalidated. So you have basically record low levels of disqualification of ballots, which gives more weight to certain votes than to others. Is that accurate enough?
So yeah, effectively his claim is twofold. It's an equal protection violation on the grounds that there was discriminatory treatment between different groups of voters. So that, for example, in Georgia, if you vote in person, you have to produce photo identification. And if you're voting early, you also sign in. Whereas if you voted by mail, you did not have to produce photo identification. You could just sign. Or in some cases, you could produce photo identification without it being in person and not sign, in terms of the absentee ballot application itself. And then with the absentee ballot, the only check on making sure that this person is the person who cast the vote is the qualified voter listed on the file, was a signature match against what would be otherwise unknown information. The theory is that someone couldn't fake. We talked about this back before the election, when I got 2 ballots in Nevada and Las Vegas. What prevents me from just sending both back in?
Take it as if one gets annulled. I mean, other than potential criminal sanctions, someone's going to say you're not going to do it because you can get prosecuted for mail or for voter fraud. You might say, "Oh, I forgot that I mailed one in here." But other than criminal prosecution, if enough people just take their chances, and if it gets disqualified, so be it. And if it doesn't, hey, it's 2 votes.
Exactly, and the check was supposed to be, well, they're going to check the signature, and I couldn't possibly know what this other person's signature was on file, on their driver's license or voter registration file. So that would be a check. They would catch that. The Las Vegas registrar made the promise that, hey, we'll catch these. Well, a reporter in Las Vegas actually tested it out. He had people send in 9 fake forged versions of his signature. They were obviously fake. They missed 8 of the 9. So that gives you an idea of what was happening in Las Vegas. And the question is, was this happening everywhere? And at least from the low rate of rejection, the inference is that something happened. Either everybody somehow got perfect signatures, or something happened that in the signature match process. And in Georgia, the issue that arose was this consent decree signed by the Secretary of State in 2019 that created a cumbersome bureaucratic process if you were actually going to reject a signature, that may have led to counties saying, this isn't worth the hassle. We're just going to approve signatures unless there's no signature. And they also had a notice and cure process, whereby if a voter's ballot was rejected, they were given the opportunity to produce identification and say, yes, that was me, and here's my signature.
And if I'm not mistaken, according to the lawsuit, that procedure was only applied in certain counties that were more Democrat leaning than Republican counties? Is that one of the elements of the lawsuit as well?
That's in Pennsylvania.
Okay.
So in each state you have your own issues, but a lot of them revolve around two major problems. One, that the signature match process doesn't seem to have been enforced. In some contexts, that's a witness requirement in Wisconsin, in Michigan, in Pennsylvania, in Nevada, and in Georgia, it's the voter themselves. And the second is lack of observation, lack of transparency. The recommended rules and procedures by the best practices guides from the Blue Ribbon Commissions and the bipartisan committees has been to make sure there's more transparency so people can watch the process and have faith in it. Unfortunately, such as in Georgia, there had been a request made to observe the signature matching process. It was denied. So they said originally they would grant it, and then the way in which they granted it made it impractical. In other words, you couldn't see what was happening. I think people have been commenting on that publicly in Georgia. They're seeing people count ballots, and the people that are supposed to be monitoring it are so far away from the table, they can't possibly see what vote they're validating and to see whether they're voting.
And just to push back on that in terms of raising the argument, the counter argument that was stated in the lawsuit we're going to get to in a bit, Michigan, they said, okay, they were not allowed within 6 feet to see, but they had screens showing what was going on. Having not seen those screens, I don't know if it's totally impractical, totally useless, or totally illusory to pretend that was any sort of meaningful verification. But that will be the counter argument that you're going to hear. What is the response to that? They had screens, they could see it on a big screen.
So people can go, at least in the Georgia context, and they've been live streaming. Some of the counties have been live streaming, and you can see that what you're seeing on video, you can't see the ballot at all. So the point of the monitoring isn't just to say, oh, look, this person's claiming to be counting something. The purpose of the monitoring is, are they properly interpreting voter intent on that ballot? Now, obviously, in the computer printout ballots, that's really not going to be an issue. But in the issue of the hand-filled out ballot, that's where it could become an issue. So you have situations where people do a check mark or other things where the machine might have recorded a ballot, but when you look at it, it was improperly concluded. The whole point is, this was the debate in Bush v. Gore, what interprets voter intent, and the goal is to have somebody observing it that says, that's a fair interpretation, or, hey, I object, let's have this process go through because I see a problem with this particular ballot. And again, it's all about transparency and confidence in the system. And it's unfortunate that, people spent 20 years building these great rules and procedures and best practices. To see them continually ignored in all of these jurisdictions is really unfortunate.
Okay, so now we know how you feel about people think I'm saying Ellen Wood. Ellen Wood. We know the other issues with Rittenhouse and whatever. The lawsuit seems, by comparison to the other lawsuits that I've read, seems well drafted. It seems it's clear in that I read it. It's shortish, like I think it was 30 some odd pages. It's concise, it's well structured, and it's clear enough for people to understand without getting into the nitty gritty. Overall, how do you feel about the lawsuit, and what's going to be the procedure? Like, how quickly can these lawsuits be heard given the upcoming December 14th deadline?
So across the jurisdictions, you have a suit in Michigan in state court, a suit in Michigan in federal court. You have at least one suit in Pennsylvania federal court. You might have multiple now, and suits pending in Pennsylvania state court. I think there's a recount request in Wisconsin. There may also now be a suit in Wisconsin. In Georgia, there are multiple suits pending. So there's Lynn Wood's suit filed in the Northern District of Georgia, pending in the Atlanta Division. There's another suit that's been filed in the Savannah Division. In fact, the same local Georgia counsel is involved with both. There's a lawyer from outside the state that's involved in the Savannah case, asking for different remedies based on anomalies that have been spotted. The issue in the Lynn Wood case is a combination of equal protection and the Electors Clause, because the argument is the state legislature is the only one that can amend the law governing signature matches. For people on the you may not understand how equal protection applies in this context. It's your vote. You have a right to your vote being counted, and that your method of voting shouldn't lead to them being where you happen to be within a state, which county you happen to reside in, and your method of voting shouldn't lead to a discriminatory, differential, disparate treatment of you. In addition, you have a right against vote dilution. So any method of voting that allows or opens the door for fraud to occur dilutes the votes of those honestly cast.
And it's a good line. I heard it somewhere where, one line is not counting votes is voter suppression. I saw someone respond on Twitter that says counting illegal votes is voter suppression because you dilute the legal votes. And I see legal as in legitimate versus illegitimate votes, the ones that should get disqualified, the ones that might have been cast by someone who's not a resident. So the flip argument to suppressing the vote or not counting votes is voter suppression. Counting illegitimate ballots is also voter suppression. Sorry, I cut you off there. Go
yeah,
on.
No problem. In fact, the California courts have referred to illegal votes as any vote not lawfully cast. It doesn't even require fraudulent intent. It just means a vote, like let's say a vote that did not arrive in time, a vote that did not meet certain protocols and procedures for being lawfully cast. So it doesn't require even fraud to have occurred. So that's where the scope of the litigation is. They have requested different remedies to different courts. And the hard part with all of these cases is, in my view, the Secretary of State, if they stepped into the breach, and the local county registrars or election officials or superintendents or election boards, as the case may be, if they'd stepped into the breach and said, hey, let's make sure we have a transparent, open process. Let's have a manual recount where it's monitored and observed. Let's have people review the signatures so people can see, yes, the signatures do match. If that's the case, let's make sure the votes add up to the voters. Let's make sure there's no machine or software issue. That is where our system is designed to work. When the secretaries of state don't do their job, or when the election officials don't do their job, is when problems occur. And the difficulty there is that both courts and Congress, who are the legal remedial powers that be in the presidential elector context, including theoretically the electors themselves, the putting them into stepping in or stepping up has historically not always been a very effective remedy. And I think that if they don't step, instead they sort of create massive pressure for people to just concede and walk away. And I think a lot of the pressure to do that is a mistake. It's not going to lead to confidence, even if a concession occurred. It's not, there's going to be millions of Americans who rightfully wonder why certain basic elementary steps could not be taken to verify the vote.
Well, I mean, it's like you're pressuring someone to concede who has 70 now. What's Trump up to? Regardless of what the difference is, 75 million people voted for him, and 75 million people did not vote so that he could concede under pressure of the media and whatever apparatus has been against him for the last 4 years. In the presence of all of these things, might be totally coincidental. They might be exaggerated. There might be some false, what's the word I'm looking for? Controversy, like maybe with Sharpiegate lawsuit, which may have been unfounded. But you have people who are smelling a lot of fishiness and would not take kindly to that, to someone saying, okay, well, I concede and, thanks for your vote. So it's true. Like the lack of transparency in this entire process, given the margins, it's not like if the margins were greater, maybe, you could get away with people accepting the results more easily. When the margins are less than 1% in 4 battleground states, and in some places, minuscule amounts given the 5 million votes cast, you have to have more transparency. And when you have more aversion to more transparency, people get more nervous about it. Someone asked a question about curing the ballots. The curing the ballots was in the Pennsylvania lawsuit, right?
Correct, because it depends on the state. Over the last several years, they've been mostly people aligned with the Democratic Party have been bringing suits challenging striking of absentee ballots on the grounds that there should be an opportunity to cure. My own view is I have a little bit of, I have mixed sentiments on that subject. My view is that more in-person voting is better and safer, and anything that encourages that should be incentivized, and that absentee balloting should be discouraged to the scope that it invites voter coercion, voter fraud, vote purchases. It's always been problematic. I mean, the whole point of having an Australian ballot, which is what the secret ballot came from Australia, so we call it the Australian ballot, is completely gutted when you're not voting in a secure, safe polling place under supervision, where your ballot is actually secret. Absentee ballots are not secret by definition, because you don't know where they cast that ballot, whether they were the ones who cast that ballot, whether someone purchased their ballot, whether someone intimidated them to do the ballot. In fact, the New York Times article called it granny farming, where people go to nursing homes and get a bunch of ballots that they don't even know that who they're signing for. So my own view is that making it easier to do absentee balloting is making it easier for voter fraud and voter coercion to take place. But putting that aside, a bunch of states basically were threatened with litigation, and a bunch of them changed their laws or agreed to consent decrees whereby they agreed to basically allow someone to have a chance to cure if their ballot was rejected. And so again, I have mixed feelings. I want a voter's vote to count and not be improperly rejected, but I want voters to also be encouraged to vote in person, because that's the best way to solve that problem, rather than voting by mail. But in Georgia, they have that. In other states, they did. Now, what happened is in some of the states, Arizona, they tried to get that passed in a certain way so they could go past the election. That was rejected by the Ninth Circuit. In Pennsylvania, they tried to get it. It was not accepted, but a bunch of counties did it anyway. And that's where you had disparate treatment. So if you were in a Republican county and your ballot was rejected for any reason, you were not given an opportunity to cure. But if you were in a big Democratic county and your ballot was rejected, you were given an opportunity to cure. So you had a bunch of ballots count in one county that wouldn't have counted in the other. That's a classic equal protection violation. The question is whether the courts are going to do anything about it.
Well, and now if I can stop you there also, one of the questions, and it's the one I think I've been hearing in the media, it's only a few thousand ballots anyhow. It's under 10,000 ballots. The difference is so great that it won't change anything. So why bother remedying that deficiency, even if it is a bona fide deficiency?
It's simple. My view is we got to fix these deficiencies now for future elections. So that's where I believed and have encouraged people to take legal efforts to reform the structure, fix this now. And people were asking about the runoff in Georgia. Well, I mean, given the debacle that was the November election, why does anyone think that the runoff is going to be anything other than chaotic as well if we don't fix these problems now? And not only that, if there was massive voter fraud, and then like I said at the earlier in last week's live stream, there's a lot of statistical evidence that it has indicia and badges of fraud having occurred. This will be encouraging those people. They'll say, look, we got away with it. And you think they're going to stop? They're going to increase it. So we need to build confidence in our elections. We have protocols and procedures constitutionally and by various blue ribbon commissions and independent bodies to utilize precisely for this circumstance. They were written for this. And we just need election officials to abide by it. And if they won't, we need courts to mandate they do. And if they still won't, then Congress has to step into the breach as the Constitution intended. Now, do I know whether that will happen? I think that's the uphill battle. The uphill battle is that, is getting people to do their job, unfortunately, has been a hard thing these days.
Well, and now because I follow Scott Adams on Twitter, and he's trying to defend one of his predictions that there's going to be two presidents at the same time, and the one reality in which he sees that potentially happening. Fine, Trump concedes, but it's concluded after the fact that there was not massive, not widespread, but relevant material voter irregularity. Now, let's just assume that the system is broken, the system gets fixed. That's a small consolation prize to the fact that the system was broken and had an impact on this outcome. So that might not make anybody happy. That's one of the outcomes potentially. It's like, okay, we see some holes here in the ship. We're going to plug those. Too late, so sad. And now we move on to President-elect Joe Biden. Trump can claim moral victory, but this is the presidential reality that we're living in. I mean, that's one potential outcome. More likely than actually rerunning elections or auditing some of these battleground states to actually confirm the outcome?
I would hope not, but you never know, because the people that will have the power, three groups of people have the power to, I should say four really. The Secretary of State and election officials have the power to take corrective action. Then next, the governor really has power to take corrective action. Now, in states like Michigan and Wisconsin and Pennsylvania, they want Biden to be declared the winner, so they may not do so. In a state like Georgia, you would hope the Republican governor would take corrective action, would want there to be confidence in the election processes in Georgia. He was the former Secretary of State in Georgia. And the same with the courts. You would hope the courts care enough to say, hold on a second, we should make sure everybody has confidence in this election. We got all these rules and procedures for a reason, for this exact situation. Let's use them. And the fact the Secretary of State won't do so or the governor won't do so is no reason for us not to do so. Because what I can tell you is under Freedom of Information Act or its equivalent Open Records Act or other sunshine laws, many of these records, such as signature match records, are discoverable information by the public. So sooner or later, somebody's going to do the check. Someone's going to do a signature match check. And they're going to find the means to get it done. And if it turns out there were enough votes in doubt as to who won, then all of these courts and the Congress and the politicians will have badly failed the American people, and the whole world will know it. So I'm hopeful they take corrective action, but I'm also a realist. I recognize that there's a long history of people not doing so, and then clearly there's a massive media campaign to do otherwise. And it's my argument to everyone. If you are on Joe Biden's side, you want an accurate count so that people have confidence in him if you believe he honestly won an honest vote. The fact that all of your Democratic allies are screaming, please, please, please don't do a signature match check. Please, please, please don't do an audit. Please, please, please don't do a full hand recount that's monitored, tells me you don't have confidence that your candidate actually won.
And I'm going to pull up Cleopatra's super chat. And by the way, thank you very much, Cleopatra. Thank you, everyone. Please explain the hammer and scorecard. Are they relevant? Will they help in any way? Thank you, Viva and Barnes. And this relates into the other question, which is, who is it? Dr. Shiva, who has who's prepared basically the most comprehensive statistical analysis to give the, as you say, indicia that there might have been some fraud. Those two play together. What did Dr. Shiva say, and how does that play into the Hammer scorecard?
So the allegations are that Hammer and scorecard were intelligence-derived technological tools that may have been used to influence the election in some manner. There's comparable allegations that have been made. I haven't confirmed and don't have any part of, but concerns about Dominion. What I can say, which is the election software and other election software that may have been utilized that were associated with glitches that misreported votes in both Georgia and Michigan. My view is I've always been a skeptic of that kind of technology. I'm in favor of using like blockchain type technology as a complement to existing voting methods if we can incorporate it in such a way to help secure the vote. But I still prefer the old school methods. People will always have more faith and confidence when you go in and fill in your actual ballot and a human being counts it. When we have computers involved, when we have machines involved, many Americans are always going to be skeptical when we have a very close election, particularly when the owners or people who sit on the board or people that have security positions of those companies are hostile to one of the candidates. This invites trouble. And by the way, it's been both sides. There was election voting software companies in 2000, 2004 that had ties to the Bush family that led to concerns on the left. Now there are concerns on the right because of some of the connections with some of the election software companies and mechanical companies. You know, my view is I get why politicians do it. They see it as streamlining their task. They see it as reducing their labor cost. But in my view, labor cost is worth the price of confidence in the election outcome. And this is not a place where technology is an easy or effective substitute for simple human involvement and human responsibility. I don't know whether, I know Sidney Powell and other people have made comments. I don't have personal information about that one way or the other. I do understand why there's concern. I think, again, that's a concern that a manual recount that's properly monitored would resolve a substantial portion of that.
The idea is, like, even if you do targeted manual recounts or targeted signature comparisons and you don't notice any anomalies, then you could sort of already say, well, we can extrapolate that there, if we don't see anomalies within certain targeted areas, then you can extrapolate there won't be in other areas. And same thing with a recount. Start with certain specific, highly relevant, highly determinate counties and battleground states. And if there's no anomalies, then people will already start to feel a little better. If there are, then you know that you have to dig a little deeper and expand the scope of the recount, expand the scope of the signature comparisons. Incidentally, there's an argument in the comment section as to whether or not Dr. Shiva was debunked or not debunked. You'll correct me if I'm wrong, Robert. I think it's relatively universally accepted that if you're going to have to start making your evidence of election fraud via statistical analysis, you're never going to sway the public opinion, and it's going to be very difficult to sway the courts. What you need are concrete examples of, as we've seen, and as was highly detailed in that New York Times article, concrete examples where it was either computer software glitches, manual issues that resulted in the false winner being declared and not statistical analysis. But I mean, what's your take on that?
Two things. I mean, I always use statistical analysis as a way to know whether there's a risk or indicia or badges of fraud in an election. Now, in terms of its evidentiary utility, that varies. What I can say is that election contests have been brought by Democrats in Georgia after 2018, for example, where their only basis was a disparity, a drop-off in voting from governor to lieutenant governor. And that they simply pointed out that a number of votes, there was about 95,000 votes that dropped off, people who only voted for the candidate for governor, but not the same party's candidate for lieutenant governor. And they argued, based on statistical anomalies, that itself was sufficient to bring an election contest. So my view is that it is relevant evidence because it's often the only evidence you have. Now, it's true for all the statistical evidence that's out there. There's been a counter made. So whether it's Benford's law and whether the law, whether that method of statistical analysis should apply in the election contest, that's controversial. Dr. Shiva's analysis, some people have contested it. I wouldn't say refuted it because it's more contested it. In other words, the data is the data. They aren't saying he made up the data. They're saying they disagree about whether his interpretation has the evidentiary inferences that he alleges. The reality, I thought Professor Turley made a fantastic, constitutional law, generally left-leaning professor from George Washington University. He came out and said, look, he goes, the nature of election fraud is that you're never going to have the evidence of it without discovery, without the recanvassing or recount or audit place taking place. Because how do I prove a signature match didn't happen when I'm not the one who ever got to observe it? Other than the statistical inference that, hey, something unusual happened here.
No, and you get you get all of the mainstream media pushing that there's no evidence of I'm not even going to use the word fraud, irregularity. Well, of course you have no evidence of irregularity. You haven't even bothered to look yet. I asked Stelter, I'm not even doing it on purpose. I asked Brian Stelter, not that he's ever going to respond to me. Has he read any of the lawsuits? I don't care that some of them got dismissed. I don't even think people understand the ones that got dismissed and why. But of course, they're not going to. They're covering their hands over their eyes, ears, and mouths, and they hear no irregularity, see no irregularity, speak no irregularity, and they conclude that there is no irregularity. There's no evidence of it. Nobody's been looking, except for the people who've been looking and have found some. And then you get the New York Times detailing it, but then saying it wasn't material, or it was rectified, it was remedied, and there's always some. But it is. It's arguable whether or not Dr. Shiva was wrongly debunked and so on, but no one's going to find it if they're not looking for it, and they're definitely not going to find it if they don't even do that which is normal when the race is close.
Exactly, especially when this is why we designed all these rules. Why not utilize them? If we're not going to utilize them, why do we have them? So people spend a lot of time, years and years of effort to come up with, okay, if we have a closely contested election, what procedures can we use to get confidence in the outcome amongst the broadest range of people? And there's very simple rules. They're pretty easy. And my view is this: if it's the case that an honest signature match, independently observed and confirmed, would show that Joe Biden is the winner, then everybody on the Biden side should welcome that. The fact that they are all scared of that simple check being utilized. This is like saying, no, I didn't steal any money in my bank account, but you can't look at my bank account. No. You can't prove I have that money in my bank account because I'm not going to let you look at my bank account. I mean, come on. Clearly something is afoot. And I'll put it this way. I will always believe this election was stolen if we are never given an honest recount, an honest recanvass.
I go one step, not one step further. I just have a different angle. The harder the media in unison and in tandem tries to push something, it makes me suspicious. But the fact that they have been consistently wrong in what they have pushed in other meaningful situations, I would have to be an idiot to not ask the question, why are they doing this? Why are they pushing it so much? And now it might have been a sincere mistake at the beginning, but now they have a vested interest in protecting their original projections because they've basically set 77 million people up to rightly be enraged if what the media has been telling them for the last week ultimately is overturned, which is the wrong word, is not confirmed. So they have a vested interest in covering up their initial mistake if it was an initial mistake to prematurely project. Sounds very dirty. But they have a vested interest to cover up that mistake. But we know that for the last 4 years, they've been against Trump in the first place. And so this is just more pressure to get what they wanted for the last 4 years, and to pressure everybody else into silence, to being labeled whatever the C theorist, to even dare question and to even dare ask for the basics to be carried out in accordance with rules that most people don't even know exist. But the harder they push, the more questions I ask. It's just it's experience, not even skepticism.
I think the biggest hurdle is this public media narrative that is discouraging, and mostly it's really aimed at Congress and the courts to not take meaningful corrective action. And again, the corrective action isn't to overturn the election. The corrective action is simply to make sure we have an honest vote with the very easy methods and means we have available to us to assess and ascertain as much as we can the honesty of the vote. I mean, there's certain kinds of voter fraud that you would not be detected by these mechanisms and methods and means. But at least the ones we can detect, we should utilize. Otherwise, why have them present?
And easily used. Now, Cleopatra's asking a question. It says, "What if will this go to the Supreme Court? And if not, why? How can we accept an election which has shown provable fraud?" Well, here's the bigger question. It'll cover this one as well. In the event that the contestations are not resolved by the 14th, then what happens?
So theoretically, it depends on the governors. So the state executive. So, for example, if the contest is ongoing and they have not made a determination, then they're out and they don't send a certification because they don't yet have a determination within the safe harbor clause, then the Electoral College does not have to accept whatever electors that state sends. Or it may be the case they never send electors. So what could happen is you could have states saying we can't certify this election because the outcome is in doubt. And then what the constitutional role is, if neither candidate has a 270 or more electors voting for them, then that's when it goes to the House. And it goes to the individual by state delegation. I've always felt that is an underutilized remedy. I was in favor of Gore doing it, even though it was a foregone conclusion that Gore would lose that vote. I was in favor of that because I thought it would restore constitutional confidence to the outcome. And if people didn't like it, take action in the House in the midterm. I would like it to happen here. I'm seeing very little discussion of it. I see talks about state legislatures. I see other talk. In my view, there's a lot of members of Congress that don't want to fulfill their constitutional duty. They would like that burden not to be upon them. They're in their own Garden of Gethsemane. But they're not exactly the same person who was there. So unfortunately, in character or constitution, it's unfortunate because our founders anticipated this possibility and said, let's let the political branches, the directly elected members of the new Congress, determine who the president is if there's doubt about what the vote was in a majority of the electoral votes, and do it by state delegation. It happened. Put it this way. They would already be recommending this protocol if Democrats had a majority. So and I would still be in favor of it, even if it was a foregone conclusion that's where it would go, because that's, again, the constitutional remedy. That's what people voted for members of the House, knowing they have these kind of constitutional powers. And that's the political branch responding to a political problem. So that's my own personal belief as to what should happen. That's what the Constitution actually enshrines. If these states really don't know who won because there were too many ballots cast that should not have been lawfully included in the count, then that's the constitutional remedy.
Okay, that's very interesting. Now, I think there was another question that I had on that. Okay, no, so that basically means if neither party gets to 270, it goes to the Senate.
No, it goes to the House, and they vote by state delegation. Now, the way the protocol works is, let's say they come back and they say, yes, there are more than 270 electoral votes for one particular candidate. At that point, a House member, under the current law rules, now my own view is they could create their own rules constitutionally, but let's say they stick within the current statutory schema. Then what happens is a House member and a Senate member must both object. It's not real clear in the rules. It appears that the House and the Senate both have to come back and both sustain the objection or the electors count. That is contra what the Constitution intended for that process, but that appears to be the current statutory process. They would likely follow it even though they don't have to. And given that, that appears not to be a vote by state delegation, which, again, I think is contrary to the Constitution's intention. But right now, even if the electors were included in the Electoral College, there is a means to throw out electors if there's a basis to challenge that. But it appears that it would require the consent of both branches in order for that objection to be sustained. So that's the next option along those lines. That they requested that in Bush v. Gore. A bunch of Democratic House members made an objection, but no senator joined them.
Okay. Now I'm just reading Sarah Severson says, I thought it was the state legislatures who could choose new electors and not the governors. Please clarify. Thank you.
This is where there's a gap between what the Constitution provides and what the statute provides. So what the statute provides is the statute requests that the executive from of the state certify who the electors are for the Electoral College. The Constitution says the state legislatures get to pick how electors are appointed in the first place, and that they can withdraw that and change that at any time according to various interpretation of that clause. So the theory is, couldn't the state legislature step in and say, we can't determine who the electors are because of what happened in the election. We are going to send a different group of electors to the Electoral College, while you have a federal law that says the governor can send a different set of electors. And then you have a whole different issue on your hand.
Okay, that might have made it even more confusing to me, but I'm gonna rewatch tomorrow and redigest. So the question is, I guess I wanted to clarify one thing. Something you're hearing in the media, I forget who it was. I think it was someone on Joe Biden's transition team, talking about how Trump's lawsuits have gotten thrown out of court. They're being laughed out of court, so on and so forth. Correct me if I'm wrong, and I don't want to mischaracterize this. The lawsuits that have been dismissed that Trump had filed, typically, if not all of them, were lawsuits relating to injunctive relief, relating to the count, access to the ballots the night of, and the sort of supervision during the actual counting. Those were tossed because by the time the issue came around, the ballots had already been counted and they were effectively moot. Is that oversimplifying?
No, that's a large part of it. And I would say Democrats are making, in my view, a tactical mistake, and some of the courts are too, by taking pot shots at this. Now, I'll tell you up front, this is how courts tend to respond to election fraud cases. They tend to, frankly, be complicit in covering up election fraud rather than exposing it. And I've been complaining to courts for a long time about this in a wide range of contexts. And saying, look, they think by being over the top and making little pot shots that will read well in the press, that they've won their case. All it does is anger and intensify the doubt of those on the other side. It never achieves the objective they think it does. It reminds the world of their arrogance and their insolence and their lack of connection to ordinary people and their concerns, and frankly, often a lack of respect for their duties and their jobs. You know, acting like the judge in the Roger Stone case did does not instill confidence. It instills doubt. And maybe someday judges will reopen their eyes to this. But this is what happens when they live in their own echo chambers, to where Sullivan can do what he does and not recognize he's completely discrediting large aspects of the judiciary to millions and millions of people. So that's my argument to any of these judges that are taking little pot shots, like I think in certain respect the Michigan State Court judge did. Look, if you want to side with the state against the other side and just take their word for it, that's your privilege. But be careful what pot shots you do, because then you're just going to look like a political hack who predetermined the outcome to favor your side. And if you don't think people on the opposite, Republicans, aren't going to think that about you, you're in la la land.
Now, actually, it's a good segue. We're going to come back to Johnson's question, and we're going to come back to the 10,000 dead voter question as well. Michigan, 1 hour and 19 minutes. The Michigan lawsuit was not a Trump lawsuit. It was a citizen lawsuit. They filed seeking injunctive relief. What else? Restraining order. Ultimately, now I did a vlog on it. And everybody can go watch that if they want. But ultimately, the judge dismissed the lawsuit. I say on a technicality. It was not on the substance of the lawsuit. The bulk of the dismissal of the lawsuit, was that the plaintiffs have alternative remedies such that the injunctive relief is not warranted. It's not for the courts to get involved. And what do they say? What's the word when the benches are active? There's a word for an activist judge. Whatever. It's not for the courts to solve the problem, to craft the solution. It's already in the law. So if you want an audit, the law provides for pinpoint audits or county audits, and the court has no business intervening. That's fine. So that's basically to say we didn't have jurisdiction really because the legislation provides an answer that the courts are not supposed to get involved with. My question is, knowing that that's going to be the answer from the court, why go into an assessment of the evidence and provide so much opinion on the evidence when ultimately the judge could have assessed the evidence the exact opposite way, come to the exact same conclusion, and still dismissed the lawsuit for the same reason? That's where I got the feeling that, for anybody who didn't read this judgment, the judge basically says, you're 7 affiants filing affidavits in support of the motion who think they saw things, who did see things, who saw a truck show up with out-of-state plates to deliver ballots at 4 a.m. through the back door of the counting room on the 4th. You have affiants saying this. You have the judge saying, I don't like your affiants. I don't trust them. One of them was posting, theories on Facebook posts, so his credibility's shot. The other person who saw an out-of-state plate on a truck, it was a rental truck. You're ascribing sinister motives. Basically, the judge said, I don't trust any of the affidavits or the affiants in support of the motion, and I trust all of the defendant affidavits, which were Democrat Party affidavits. Am I wrong in thinking that the judge did and said all of this, says push it back to the government now, but here's what I just said, and here's how I colored all of the evidence that was presented by the plaintiffs?
That's exactly what he did, and it was a political hit job. And it's not a surprise. I mean, one of the weaknesses of election contest litigation is that in most state contexts, you have to file suit in state court in the state capital, the county, wherever the state capital is. Of course, that is these days a heavily Democratic audience almost exclusively. And so you're seeing judges that were very tolerant when election contests have been brought on behalf of Democratic candidates suddenly become overtly hostile and completely state deferential when it's a challenge to a potential Democratic presidential election. And I think they've approached all of it the wrong way. As they should have looked at it as, if you really don't believe any fraud occurred, then have it be as open and transparent account as possible to prove it to the world beyond any question. Don't behave like the Kennedy, the Kennedy assassination committee. Don't behave in a secretive, surreptitious manner that encourages and incentivizes doubt. Do the thing. You're a judge, for crying out loud. I mean, the point of a judge is to instill confidence in the objectivity and neutrality of the law, and you as a law decider, adjudicator. These judges are doing everything the opposite way. They're taking pot shots that, if I knew nothing about the case and I just read the judge's ruling, I would say, wow, this is a biased judge. I mean, that's not how you should write an opinion if you're a judge, especially in an election contest. If you'd say, hey, I see why they thought this. Here's where I don't think it necessarily goes there. But the other thing is, he could have just, as you note, he didn't need to say anything about any fact. You'd say, look, the remedy isn't here. So when he went out of his way to take pot shots at people who clearly reported accurate information, he was trying to be dismissive of it. I'm sorry, it's weird when you rent a truck to have ballots go from one place to the next in the middle of the night. Maybe it's normal in Detroit, but it ain't normal in the rest of America. So so I think the over-the-top approach, I've seen this in Law and Crime and other people who reported on the Savannah suit. And it's like, look, yeah, there may be limitations to what those suits can do. There may be the inability to get the relief that they want. Maybe they can't prove up all the claims that they have. But treat these people with respect and honesty so that everybody can have confidence in the election and have confidence in the judiciary. And sadly, I'm seeing neither being done, particularly in the legal press. The legal press is anxious to take little snide pot shots at people. And they still haven't figured out from 4 years of Trump that laughing and mocking these people does not instill confidence in you, the press. If you don't want Alex Jones to be twice as popular, behave like an honest press, not a dishonest press. I became involved in this without going into details of how, because of things like this. They're treating ordinary, everyday people who have sincere, straightforward questions like they're jokes and crackpots. And it's a dishonest judicial process that's doing it, dishonest executive process, and a dishonest press. And someone needs to push back on it. So, I'll be one of them.
And just so that everybody can appreciate this, I didn't say it in my vlog. The judge could have literally not included in the Michigan lawsuit where the judge said, you're the former assistant attorney general, his knowledge paled in comparison to the other affiant. And maybe if you had attended the pre-election walkthrough, you would have known better. You could have asked your questions then. Incidentally, I did something I did not know at the time I made the video. Apparently they weren't invited and they didn't know of the walkthrough, so they couldn't have done it anyhow. But the judge could have not said anything that he said in the 10 pages of that judgment and simply said, I'm sensitive to your case, but you have other remedies under law such that injunctive relief is not warranted. Could have been one paragraph. And I'm reading it, and you know that right now, whoever takes this case, when the same petitioners go to the government and say, we want an audit, now they've got sort of, what's the word? It's not res judica. It's not over. They've got a judgment now saying, look, well, you guys are lacking credibility. You didn't know this. You didn't know that. So we're going to take your entire complaint a lot less seriously. And we have the court's blessing to do so. So if it wasn't obvious in reading it, that was my reflection on the lawsuit. And knowing more now than I knew then, I didn't even know that some of the conclusions were hotly contested by the affiants and by the petitioners. But anybody thinking, I don't know what the geography of Michigan is that you would have had to, the rental truck would have had an out-of-state plate. I appreciate that the rental car companies often have cars that go from one state to the other and they just, leave them at different locations. I would still have questions, notwithstanding what the judge said. A rental truck showing up through the back door at 4 a.m. with ballots, that is recognized by the judge. That raises some questions in my mind. And an honest press, like you say, Robert, would probably be asking those questions as well, even if the answers are totally explainable, as opposed to saying anybody who denies this is promoting fake news, slap a warning on their tweets and call them all sorts of names to discredit them. That was my rant. That lawsuit, it's not going to get appealed. It seems, I think in law, the conclusion of that judgment is the correct one. They have recourse under the law and they should avail themselves to that, failing which they can maybe go back to court.
Yes, and I think, the problem is our system is designed so that election officials are the best situated to give the necessary remedy. The problem is, in my view, and hopefully this reform comes out from this whole process, and it's one reason why I think it deserves public vetting. It's usually some sort of crisis whereby people recognize a problem and then fix it. And it's unfortunate that it requires a crisis to get there. But I hope the legislatures, and some of this is on these Republican legislatures, they fail to put in meaningful checks on this process. Many of them greenlit some of these crazy rules that got done. So let's install a real, meaningful, transparent process for elections in the future, where recounts and recanvasses and audits are done automatically all the time in every election. And they're done in a public, transparent manner that has clear rules that everybody has to live by. And I hope that will be part of the product of this process, because it's showing how much we need it. A lot of people are shocked. I think like what happened to those Michigan litigants, and I'm seeing it in a wide cross section. I forget people are not as informed as the Viva Barnes live stream audience is as to what our court system is like, as to what our politicians are like. I see a lot of people with naivete. Oh, just go to court and they'll correct it. That's unfortunately not what has happened historically when it involves major challenges to institutional power. And so you have to fight tooth and nail for it. And sometimes you need a scandal to force its change or moderation. So I've always, people have asked me, okay, what I think is the end game here. I will quote a book that I read when I was a kid. I had two favorite authors when I was 12 years old. My father had passed away some months before, and so these were sort of my substitute mentors. One was Robert Kennedy's book, To a Newer World, his 1968 campaign text, which I found very inspiring. And the other was Art of the Deal by Donald J. Trump. And one of my favorite statements in the book by Trump was, hope for the best, plan for the worst. So I always think that is a good strategy. So I plan for a system not responding to these problems, but that is no reason to forfeit in advance, because the only way you change the system is by being naive and idealistic and believing irrational things, like I'm going to ask a corrupt system to do something right, because sometimes it actually happens. And so that's the only way change happens. So I think it's a good approach going forward. I don't want people invested in a particular outcome that might not be the most likely outcome, while at the same time recognizing, okay, maybe I won't get everything, but we'll get something and it's worth fighting for. The old Dylan Thomas rage against the dying of the light. Don't go gently into that good night. I think that's a wise parable to live by. So it's the worst parts of this system have come to bear. I was afraid they would, but I'm still slightly shocked by it. That the press gaslighting everybody, the courts acting like political activists rather than objective neutrals, the Congress trying to hide under every bushel they can. It's been unfortunate seeing everybody try to abscond from their obligations. But that's no reason why we can't do all that we can to try to see the process through.
And it's a terrible thing. Like I don't know what's the word. I don't want to say a virgin. I was wet behind the ears when I first started analyzing these lawsuits coming out of the states. I was always brought up or told, you hear that the courts are politicized and the judges, Democrat judges go one way, Republicans go the other. I was naive, wet behind the ears, and didn't fully appreciate the degree to which it's almost predictive. And I don't want to make jokes in my videos about, I was going to make a joke that the judge in Michigan, his name wasn't Sullivan, but I don't want to look like I'm tainted, corrupt, or cynical as a result. And just explain it, and everybody can come to their own conclusions. And I have my own opinion. But yeah, you're reading this. There's a vested interest in not exposing the issues because it will have retroactive degrading effects on the structure and the system that people think works properly now. And if you realize that it's all been a house of cards or a sham for decades, it can cause problems. And so you have these institutions that have to continue to prop up the image of a functional system, which gives them a vested interest to downplay, undermine, write off, and brush under the carpet problems which are coming to light now. The media pressure is over the top. The big tech censorship, at the same time, I don't want to say you have to be blind to not see it, but you have to have a very you have to be very forgiving to not question it, because it's the spike of the censorship of the big tech in the weeks leading up to the election, and now it's exponential, and the media trying to control what it is that you can see, hear, and know, and to tell you what to believe. It's amazing, and it should cause everybody to be cynical. It should cause everyone to ask a few questions. And I feel like I'm the one drinking the Kool-Aid to some extent. Like, I feel like I'm the crazy one because I have these conversations with people who don't even fully appreciate this, who are still within the matrix, so to speak. And it's a weird thing. I feel like it's been an evolution. But seeing the judge do what render that decision, I was like, why did he even do that? Just dismiss it right away. Don't say anything. Don't taint the rest of the process, because they're going to have one. When I see the media, creating a situation that they cannot undo, which is going to cause them to double down, triple down, quadruple down, so that they don't get blamed for what might happen and for misleading. And people who don't even know what they don't know to know what they're being told is half the story at best. So I got this comment up here. All rental trucks are registered to Arizona for tax avoidance purposes. Possibly, but I don't know. I rented a truck in California. No, it was not a truck. It was a car. Definitely wasn't Arizona plates. What? So release the Kraken. Sidney Powell has been going around giving interviews. She's been giving very forceful interviews. And I'm not a body language expert, but I do consider myself to be, I trust my own opinion a lot more than other people's when it comes to assessing body language. I'm getting confidence and I'm getting knowledge that I think she has, that she knows more than she's able to say. But there's a part of me saying that if they have something bigger than what's currently pending before the courts, they're running out of time to drop those truths. What's your take on that? And what do you maybe think that she knows that she has not yet said?
Well, I have not had any conversations with her, so I've only seen what's been stated publicly, and I honestly don't know. So we should get the behavior panel on it. They're great, and maybe they can give us an assessment of their view of it. I think your interpretation is correct. That she has great confidence in whatever information she has, and she believes she has evidence that can substantiate it. And so will be a wait and see approach.
Like a lot of people are saying, she's a Trumpy lawyer and she's partisan, blah, blah, blah. There are things that you would not say as a lawyer, regardless. You're not gonna risk your bar certification. You're not gonna risk publicly lying to millions of people. So there's things that she's saying that I don't care if she's the biggest Trump supporter on earth. you still wouldn't say certain things if you didn't have the concrete evidence to back it up. But what are we now? We are November 15th. There's a 1 day of less than a month before we get to the certification. Stuff has got to move quickly, and it's got to move fast in order to sway public opinion, and in order to work its way into the public opinion, knowing the way it's going to get suppressed by the media.
I mean, my approach, it was always strategically different. What I had publicly recommended on here was that win the court of public opinion by pointing out the statistical anomalies, pointing out anecdotal evidence of dead people voting, felons voting, people who weren't in the state voting. There have been examples of people who weren't even in the country somehow, and they were no longer citizens of their state, hadn't been for quite some time. In fact, I believe one of them was a sneaky Canadian voting.
No, not me.
Exactly. So and otherwise, I thought that the best approach, and I still think is the best approach, is to just ask for something simple. You don't have to establish voter fraud occurred. Just, hey, I want the procedures that are designed for closely contested elections to be applied, so we have a transparent process. And we have statistical anomalies, in particular in the signature of absentee ballots. The biggest, everybody's agreed, Democratic Party, Republican Party, judges, jurists, scholars, academics, the New York Times, PBS, that the greatest risk of fraud is mail-in balloting, and we had more mail-in balloting than ever in presidential history. Let's make sure there wasn't a fraud there by using the very number one our singular safeguard against fraud, which is the signature match. So my focus was always there, more so than the technological angle. I understand where the concern is, and there's been concerns by many people on the left over the past 20 years raised about this. There's ongoing litigation in Georgia about the use of Dominion software. So my own view is I would like to see election reform where we remove the machines, we remove the computers, we remove the software, and let's do voting the old-fashioned way, which is you fill it out and put it in a box, somebody opens the box and looks at it. So I still prefer that method and mechanism. And because these kind of concerns are clearly going to come about anytime there's a closely contested election and people involved in the election software appear to be politically adverse to one party or the other. So, but I don't know where, I don't know what she's relying on. So I agree with you. She's clearly communicating confidence in the information she has, and we'll have to sort of watch and see what happens with it.
Go on Tim Pool, Viva, and Barnes. Well, Robert might have an easier time getting on than I do. I should have been or was able to. I might have been on Tim Pool, except I can't leave the country. So, and if I do leave the country, coming back is going to be. I got 3 kids and a dog. I can't be quarantined for 2 weeks on both ends. Okay, so actually coming back to a question from before, the 10,000 dead votes coming out of Michigan that People's Pundit determined. Now, here's the thing. So this is, everyone doesn't know, People's Pundit, I believe, did some sort of cross-verification system to show that there were upwards of 10,000 people, deceased people, who cast votes during the Michigan election. The media, in its vigor to disprove what might otherwise be a legit question, says, it's debunked because they went through the list, and here are 10 people that were actually alive. Here's one person that's a woman. Tucker Carlson has to apologize because he suggested that a deceased man voted, and it's actually a living woman. So they go take the list of 10,000, find however many that were in fact incorrect on that list to debunk the entire list. I don't know how the list was determined. I don't know if it's a legit list, if it's a suspicious list or an unconfirmed list. What do you know about it, and what do you say about the manner through which it was debunked by the media? Debunked.
So, I mean, they basically set up a scarecrow. They call it scarecrow argument. Straw man argument. You set up you take someone's argument and you caricature it in a way that doesn't accurately represent the original argument, so that it's easy to knock down. Hence the phrase straw man. What Richard Barris predicted was, he said, look, here are 10,000 people that appear to be, and he just put it as a suspicious list. He didn't say these 10,000 people were definitely dead. He just said these would fit the parameters of appear to be likely deceased, and we should look at whether or not they in fact are, because they're listed as voting based on the information that he has. And he's been clear all the way through it. Each process he'll say, here's a group of voters, like he'll say in Georgia, there's 130,000 red flags. Doesn't mean that they're not legal voters. It just means that there's a risk they're not a legal voter, disproportionate to the voters group in general. And my understanding is that's what he did with Michigan. And so they set up a straw man. They said, oh, he said 10,000 people who definitely were dead, who definitely didn't vote, which is not what his original proposition was. And then they find a tiny, tiny subsample who they purport to be the people within that list to say, well, at least a few are alive, which is not normally the standard. I mean, if one dead person voted, that's one person too many who voted, dead people who voted. Because here's the question you have to ask. How did that happen? The only way that happens is if someone else cast the ballot for them. And then you have to ask yourself, do you think they limited themselves to just dead people voting?
Well, and not just that. Do you think it was just a one-off? Like, okay, so you've only found 5 cases. If it's something that can be done, and you found out that it's been done once, it's like finding one ant in your house. You know there's more than one ant in your house if you find one ant. If you've never found an ant, you have no reason. And if you've never seen any evidence of ants in the house, bad analogy, whatever. But yeah, it's like if you find one or multiple cases, it can be done. The manner in which it can be done can be gotten away with. If you discover a few of it, chances are there's much more that you have not discovered. And what's the remedy to that potential problem?
And the question is the method. Presumably that dead person voted by mail. And so then it raises questions. Okay, what were our fraud checks on mail-in voting? If one dead person voted, that means our fraud check wasn't working, at least as to that one person, because how did the signature match? And so that raises questions. Well, were you doing a signature match? Were you being too liberal in your signature match? I mean, there was some recommended proposals out of Michigan where they said if someone normally has a long cursive signature and you look next to it and they've literally printed their name, they said maybe that signature matches. I mean, that's absurd. So they said normally if you do a whole long name and now you just did a scribble, they said maybe that signature matches too. That's not a signature match. They're not going to cash your check based on that signature. So I think there was a lot of that. I get they want to hide it and cover it up. But my view is rather than force on the people wanting the right rules to be implied to say, no, you have to prove fraud first. That's never been the standard. It's if there was no fraud, then you shouldn't be scared of doing the simple recanvassing that the rules are designed to do in public view that we would require any foreign country do if we were to certify their election or recognize the outcome of their election. So the burden of proof is on them to prove fraud didn't occur by simply allowing the simple check on fraud to be independently confirmed. The fact that they won't tells me something smells in Denmark, as Mr. Hamlet said some years ago.
Now, Michael Green says even Clinton conceded and the votes were a lot closer. First of all, that's why I don't like comparative arguments, because it doesn't matter. Okay, so be it. But I would not have blamed her for not conceding either. That's the thing. Is like you have a duty to those who voted for you to fight for their votes and to protect their vote. But am I wrong? Because I think Nate Brody did a video where he debunked 4 of the alleged voter fraud incidents. One was the Sharpie Gate out of Wisconsin, and so nobody goes repeating that story. Apparently, the plaintiffs voluntarily withdrew their proceedings with permission of the court when they, I guess, were presented with evidence that there was no impropriety. One of the other things that Nate tweeted out the other day was that in Michigan in 2016, there were more votes than voters in a given district. So 2016 was more corrupt than 2020. And my retweet of his tweet was like, yeah, that's the best argument for why we need more scrutiny now, as opposed to less scrutiny now, as we're dealing with districts that have had historical problems, period. But am I wrong in understanding that Jill Stein apparently called off her recounts? Some people might believe because subsequent to her recounts, it appeared that Donald Trump was actually gaining votes compared to the first time around?
Yeah, so I would say a couple of things about Clinton. One, while she publicly conceded, it was her supporters that backed Jill Stein's recount litigation. So they gave her millions and millions of dollars to have that done. And I didn't represent Jill Stein in that capacity, and I had quit representing Jill Stein at that point. I represented her in some other election access cases earlier in the election season. But that's public information. So that's part one. So Clinton conceded in quotation marks. The second part is, what did Hillary Clinton say about this election? She said Joe Biden should not concede no matter what until all proceedings were vindicated. So all Trump is doing is what Hillary Clinton recommended Joe Biden do. Third, the vote wasn't as close. This election in Georgia is much closer than any of those than anything decided in 2016 was. Same in Arizona, and at this point, same in Pennsylvania. So and I think Wisconsin is still closer than it was, but the combined 270 electoral votes is combined actually closer as a percentage of the vote from what I've seen. On that side of the equation. The second one is I think there's been this sort of impermissible burden shifting of saying you have to prove what only we have evidence of. When by definition, you're never going to have proof that the signature matches would expose fraud if you never got to see what happened on the signature matches. So, I mean, you're asking people to prove something that they can't by definition prove. They do this a lot in government misconduct cases. The judge will say, well, before I let you see this potential evidence of government misconduct, you have to tell me what's in here. It's like, well, I need to see what's in there before I can tell you whether it's misconduct or not. I just have a reasonable suspicion of it. And so that's where statistical inferential evidence has in the past been found by courts in election contest cases to be sufficient just to get to that discovery stage. And for example, in Georgia, it was simply a drop off between voting for governor and lieutenant governor. Well, look at the swing states. Look at Georgia. There's almost 100,000 people that only voted for Biden that didn't vote for anybody else in the state. That is, according to election experts, including Democratic experts in past Georgia elections, it's self-sufficient to warrant further inquiry. But at any minute, your job isn't, I have to prove fraud before I get the remedy of a recanvass. It's just to make sure the election was properly done in the first place. And so you shouldn't have to prove fraud to be able to get there, when in fact the only proof of fraud will be whether you do it in the first place.
Okay, that is definitely on point. I wonder why Clinton didn't ask for a recount.
She didn't want to be seen as the one responsible for it. That's why she let Jill Stein do it. But to your question, yes, in Detroit, two things were happening with the recount. One, it was adding votes for Trump. And the other was in Detroit precincts, they were finding more votes than voters. And that's when they were like, let's shut this down.
Shut it down. Amazing. And because by virtue of the fact that it was shut down back then, none of this really became mainstream media knowledge, public knowledge, and nobody knows. But there are, correct me if I'm wrong, there are no circumstances under which there should be more votes than voters in any given district. Suffice to say?
Oh, absolutely. And I believe that it's happening again in Georgia. We'll find out, but there's initial reports of different places where there's they bring in a ballot box, according to public reports. They bring in a box. It says there's, let's say, 5,000 ballots in there. And they count the ballots, and there's 4,800 ballots in there. And it's like, hold on a second. 5,000 ballots were counted in the election out of that box, and there's a bunch missing. Now, the way that could happen, honestly, without a person being responsible, is if the machines had errors. And we already know they had glitches. And what's interesting is, historically, a manual recount will only change about 1/100% of the total votes. That's not happening right now. There have been recounts in Michigan and for a state legislative race, recounts in New Hampshire for some local races, recounts in Connecticut. And according to Yossi Gessner, they are finding 5 to 6% of the votes were miscounted. That is highly unusual. So there may be a systemic error. And again, it may not be, it doesn't require conspiratorial conclusions. You could just have something that went wrong. You could just have glitches for any reason. That's where my view is. It's like everybody's, you have to mean the glitch has to be fraud. No, you don't. It just means we need to make sure our election processes worked, that the lawful votes were lawfully counted, that we have an honest vote that everybody can have as much confidence in as is practicable. And why all these politicians, including courts, are scared of that makes me wonder what exactly did happen in this election.
Now, Stephen Sheeran is asking, will the Pennsylvania be allowed to have their rules changed? So this is a question now. Oh, I'm sorry. One other thing I wanted to specify earlier is that among the lawsuits that are currently pending, they're not all Trump lawsuits. The ones that are some of the ones that are getting dismissed and sort of passed off publicly as being Trump dismissals, he's getting laughed out of court, are not Trump lawsuits. The ones that were Trump lawsuits that got dismissed by and large on the fact that the question had become sort of academic or moot in that the damage was done. So that's sort of the spin on the massive amounts of lawsuits that are getting laughed out of court. Trump had something of the victory in Pennsylvania. It's a small victory in that I don't want to screw it up, but that they were going to segregate and not count certain ballots that had come in after the 4th?
Yes. So the significance of the ruling was more the legal principle it established. So the number of ballots it impacted was modest, but the rule was the Secretary of State cannot unilaterally alter the rules established for the election by the state legislature under the Electors Clause, which delegates exclusively to the state legislature how the presidential electors will be chosen. And so the establishing that principle has broader application, because in the federal lawsuit that's been filed, the allegation is that a whole bunch of ballots were done in violation of the rules set by the state legislature, including no opportunity to cure selectively in certain counties, the counting of ballots without observation, the way in which signatures apparently were not checked at all in Pennsylvania. And again, when people say, I see the Fox people and some other people saying, how can you prove there's enough people? It's real easy. If 1% of the absentee ballots in most of these states, in some states maybe it's 2%, were improperly counted, that changes the outcome in the election in every one of these states. And I can tell you historically, the norm is at least that percentage in those states. So the idea that Trump could never get anywhere to prove invalid votes is just false. And again, they wouldn't be stonewalling across the country saying, whatever you do, please don't look at the signatures unless there's a problem with the signatures.
Yeah, it drives me nuts. It does not make sense that you could have had 10 times as many mail-in ballots and 10 times less rejection. It doesn't make sense. And if there's a sensible explanation, so be it. But to pretend that that's not something that should raise some flags, you have to be willingly closing your eyes, and not in a partisan way, not in a conspiratorial way. Just you have to say, I'm satisfied with the reality in which I'm living. It's good enough, and I don't want to ask any more questions. Speaking of a question, a lot of people have asked this. Timothy Locke, Uncle Salty Cracker reacts to life. Viva Robert, what about Trump's September 2018 executive order on election integrity and scrutiny? Now, that's coming up now because it was referring to foreign interference. I haven't read the executive order. Are you able to speak to this or answer the question?
Yeah, I mean, there's people who believe it could impact this election. And maybe it could. I think there has been a theory out there that Trump put this in motion like deliberately to ensnare people. That is not the case. I'm rather confident of that. So I think that is more hopeful thinking by some folks. That is not in the works, in my view. I'm speculating to some degree. Don't have personal knowledge necessarily, but that's not something. Trump's not going to go through this kind of headache as some sort of ensnarement strategy. That's my view on that. I don't think they're watermark ballots or anything like that. I don't think that is necessarily the case. I don't think the executive order will likely come into play. I know there's concern because of Dominion. I think Dominion is a Canadian company.
It was based in Toronto. I think it was Canadian. Now I think it's gone to Delaware or something. That makes sense.
And I don't know as much about that. I understand people's concerns about. It's why, having, again, software involved and hardware involved in election counting is always going to raise issues because of who might own it, because of who might sit on the board, because of who might be head of security. It's not good to have the head of security of a major election voting software company be tweeting out and Facebook posting a bunch of anti-Trump stuff. That just look bad.
Speaking to the Michigan judgment where he held that against one of the affiants who had posted a COVID-related Facebook post. If we apply the rule equally, we can be equally as cynical and skeptical and suspect of the president of the company that's determining that could in theory determine the election. So what's good for the goose is good for the gander, as we say.
It's one of my favorite rules. Learned it in law school because I was halfway through I showed up in class. And what I would do is I'd read the case in class because, that's the kind of law student I was. I figured I'd wait till the exam. But I was halfway through the Goose Gander case, but I hadn't got to that part of it yet. So the professor called on me, and I answered the question based on the first half of the case. And he was like, well, if you'd read the second half of the case, Bob. I was like, oh. But that was the Goose Gander case because he's like, hey, he lays out in the first half of the case why this rule makes no sense. But because it is one that had always been applied, what's good for the goose is good for the gander. Then that came up on my law exam question. Of course, I remember that case very well because of the class. But I've always loved that rule ever since. I think it's unfortunate. What you're seeing is a lot of press and judicial hostility to anybody who will raise these questions. I mean, you're seeing doxing of lawyers. You're seeing personal attacks on law firms. The reason why I have my own independent law firm was that I could not be subject to that kind of coercion or blackmail. But you're seeing lawyers, and the media will say, oh, another group of lawyers leaves Trump. No, what happened is their law firm was under such threat from so many people that they were forced to withdraw, which to me is embarrassing. What kind of self-respecting lawyer withdraws because of political pressure? But that shows you the kind of lawyers we have these days, sadly. But it's also frightening what's happening. I mean, I've done so much of this representation. I've been threatened every way known to man. I've had federal judges threaten me, state court judges threaten me, prosecutors threaten me, rogue agents threaten me. So I've been through enough of it that none of that deters me. But it's sad because I've seen it work on a lot of lawyers, and I'm seeing it work right now on a lot of Trump lawyers who are like, man, I don't want to get near this. I'm going to get tarred and feathered. They're going to come after my career. They're going to come after me personally. They're going to come after my other clients. And that just makes it all worse. I don't know what, I mean, it's like the media, the press, and the institutional powers that be think Soviet show trials were something to emulate rather than something to run away from. They believe gaslighting and gatekeeping are the two ways to manage social control. They don't work. They in fact, it leads to an equal and opposite reaction of people not trusting anything you say or do. So it's amazing. I'm trying to protect the system from itself, but that's the place we find ourselves.
Oh no, that and it was the Lincoln Project who doxed two attorneys and told Twitter to make them famous. I mean, that should be not just violating the terms of service on Twitter. That should be, if it's not, a relatively serious criminal offense, because like I don't care what anybody thinks. When you start going after the lawyers who represent even the most vile people on earth, you'll quickly it's Dave Pacman type level awareness of censorship. It's like, yeah, do it when I hate the person, do it. But then I'm going to come back and complain when Facebook bans me. Someone's going to do it to you one day, and you're going to realize why creating a system where the advocates literally become the targets is how things break down in a very, very serious way. So I don't know what sanctions or who's going to go after the Lincoln Project for that, or what Twitter did to them, but serious. Have we covered Trump's equal protection lawsuit versus Pennsylvania? Yes, we covered it. The state's response includes affidavits that prove that the state broke the law. Well, so we're still early in that lawsuit as well. So I'm going to cover it when there's more to cover. But between reading the Michigan lawsuit and judgment, L. Lynn Wood's lawsuit, I read through the Pennsylvania, but man, there's too much. I mean, to the point where I'm actually dreaming about this stuff, and probably not a good way. Okay, so let's see here. I want to say that we're not forgetting something. I hear someone screaming upstairs. Have we forgotten anything, Robert? And everybody, I know I had a question. No. The watermarking on the ballots. Someone had sent me just so everybody knows, also good parentheses, I get a ton of emails. I don't respond to all of them. And I don't respond to the ones where that would be asking me to act like a reporter who's going to break stories as opposed to just an analyst, someone who reads them. Project Veritas is where you want to send all of those leads. I read the emails, but I'm not, my role in this world right now is not, I don't want to break stuff. And certainly I don't have the capacity to do what is required in terms of a due diligence and verification to publicly disclose something that's not public. I'm good at reading stuff and making it make sense. What is the story about the watermarks? Because someone sent me an email, said, I didn't even understand the theory of the watermark.
A theory came out, and I attribute it to sort of the QAnon logic, which was, the way I used to describe it is people want to believe that the president is in far more control of things than he is. And part of it was, hey, we're seeing something happen that seems squirrely with this election. We don't have confidence in the vote and whether an honest vote has been taken. Maybe Biden won. Maybe an honest vote won't record that. And we would like to know, and we seem to be seeing problems with it. And they assume that, well, maybe it's part of a secret Trump plot to entrap voter fraud by allowing this to happen. And part of that is the executive order. And part of that is that all the ballots were secretly watermarked so you could track and trace them. To my knowledge, none of that is true. So the ballots are usually printed by different vendors for each state. So there is no uniform standard to my knowledge. Sure. And I don't believe there is any watermark. Now, one of the areas I've constantly raised questions about in election law over the past 20 years has been chain of custody of ballots. And to the credit of the independent commissions, the United States Election Assistance Commission, the Election Integrity Project, and Best Practices Guide, they have recommended very strict protocols for chain of custody of ballots. And one of the things that was requested in the letter that was published from the Georgia Republican Party was a chain of custody of ballots. To my knowledge, that has not yet been provided by the Secretary of State, because the concern is, the ballots are like blank checks. And so if you don't know how they were processed, then some of them could illicitly end up being counted, because the ballot is completely divorced from any trace or track of who voted in order to protect the anonymity and secrecy of the ballot. So you need to make sure, the serial numbers, how many were printed, who were they distributed to, how many are still there in inventory compared to how many were counted. And that's always an important part of the process. And the rules and the guidelines over the past 20 years have adopted those. And there's some state laws that reflect that, sometimes not always. It's a critical component. But I prefer if there were standardized printed ballots. But because each state has different issues on the ballot, each state has its own rules for the ballot. Each state has different ways of producing and printing a ballot. I mean, in some of these cases, you use a machine and it prints its own ballot that's totally separate from the ballot that gets sent to you. So there is no uniform mechanism that's nationally required that would include a watermark.
Okay, and then the idea would have been that if it was secretly watermarked and there's a bunch of ballots with no watermark, then we know that there's been outright irregularities, so to speak.
Right. To my knowledge, that doesn't exist.
Okay. Now, Douglas Bird says Chicanery T-shirt is up on Amazon merch, which is odd because I don't think I have an Amazon merch account. If only I had trademarked Chicanery. Oh, incidentally, by the way, I'm going to put this in here. The Three Eternal Truths new shirt is up. It's beautiful for anybody who doesn't know what it means. Okay, so that was the watermark. So I think that's it. We're going to see now. What are we to expect this week? Is there anything that we should be looking out for?
Well, just watch, I guess, is all I would say on that. So there are certain, in certain states, election contest may be coming up once a certification happens that has that. People can look that up. There was a good Law Journal article. I'll put up a link to a range of articles on, it's vivabarneslaw.locals.
Viva Barnes. So if anyone wants to follow us, vivabarneslaw.locals.com.
That's
$5 a month plan thing there, and you get some exclusive content there.
Exactly. For the subscribers, I'll be putting up some stuff that will be links to some of these articles, because it's fascinating. There's the election contest. Like in Texas, it's the governor who unilaterally decides an election contest. In some states, it's like 3 randomly appointed officials. So it's fascinating. I followed it, but I hadn't followed it in the presidential context until recently. And it was really intriguing to watch. So there's different election contests that can be brought in different states. You'll see the federal lawsuits moving forward. I believe Sidney Powell is talking about bringing additional claims. Rudy Giuliani is talking about bringing additional claims. Maybe we'll see what evidence they have to support that. I hope that election officials will step into the breach and give us an honest recanvassing and recount so that we can know whether the signature match occurred. We can know with a hand recount that the computers didn't screw up the vote. And that would be 2 great additions to inspire confidence in the outcome of the election, whichever way it may come out. If that does not happen, then there will never be confidence in this election by millions of Americans. And that will be the failure of both courts and executive officials in the state governments.
All right. Now, Dapper Dave wants to know, can Robert say in general why you are in Georgia?
Well, just follow the news.
Oh God! This is the most exciting time to be alive. Everyone wants to know how this ends, but that would kill all the suspense and the excitement. There was a question I had about Georgia. Yes, the Georgia runoff election. What about the law that we're hearing about people encouraging other people to go move to Georgia to vote? Now, logistically, they would have to go. They would have to get a domicile. They would have to get a utilities bill, and they would have to change their license or something? What would they have to do in order to be eligible to vote in Georgia?
It doesn't matter, because in order to be eligible to vote in a runoff, you have to have been eligible to vote in the general. So you can't now move to Georgia and participate in the runoff election.
Why couldn't the media just say that instead of entertaining this idea? What of the idea that, what's going to happen? This feels like a movie that that the entire control of the American political apparatus is decided by a runoff in Georgia, and you're going to have celebrities and politicians dissenting. It's going to turn into like Aspen, Colorado in the middle of winter. Is that actually what's going to happen, in like practically speaking?
Potentially, and I think how Georgia handles its recount, if they would do an honest vote so we could get to a determination as to at least those aspects of the process within easily accessible control as to what the vote was. If they don't do that, it may have a detrimental impact on the runoff in two ways. One, it may impact turnout on the Republican side of the aisle if Trump voters believe that the senators did not do enough to support an honest vote in the first election. The second component of that is we're going to have if we had a bunch of mail-in ballots that it turns out were illegitimate, what's going to stop that from happening again in the runoffs if that isn't fixed by some legislative or judicial action or executive action here in Georgia for the runoff election? That's why, I've been telling people down here that we need honest, and telling people everywhere publicly, we need honest elections for confidence in democracy, period, whichever side you're on politically. And I have some of my friends on the left who agree with me, who've quietly provided information in support of what's going on to get an honest vote. But I think that too will matter and there may be litigation about that coming up because there needs to be an honest, monitored, observed signature match process on absentee ballots. They need to make sure they don't kick out observers out of Fulton County, like apparently happened on election night, told them that, hey, don't worry, we're not going to count any votes. You can go home. And then they start counting votes. Same problem happened in Pennsylvania. Same problem happened in Michigan. Same problem happened to some degree in Wisconsin. There's no reason for that to ever occur. The observer part of the process is the number one standard required internationally for election observers to certify or justify or recognize an election in a foreign nation. Why we can't follow the same rules ourselves is beyond me. And using COVID as a pretext for this is nonsense. So it discredits the election to be doing things this way. You can even do things like digitize ballots and let everybody see the ballots. I mean, it's a recommended guideline of the best practices by the Blue Ribbon Commissions.
Actually, on that topic, you reminded me of another question. What's the controversy apparently of certain districts, certain counties having destroyed the envelope in which a ballot came as opposed to preserving it? There's a rule that they have to preserve the ballot for 22 months or something. Do they also have to preserve the envelope in which it came?
Oh, yes. For this precise point, for this precise purpose. If people review things like the United States Election Assistance Commission, they have a whole election guidelines book. It's available online. You can read about canvassing. And again, this was a bipartisan commission set up by Congress to resolve the problems that happened after 2000. And what they outline as part of canvassing or recanvassing is you bring out the absentee ballot application supposed to be kept. You bring out the absentee ballot envelope that was supposed to be kept. And in fact, my understanding is many of the counties across the country are digitizing those records. And they really should. It would help preserve and protect them. And like in addition, in Georgia, if somebody helped you fill out the ballot, that person also has to be identified and they have to sign on the ballot, on the envelope that goes back in. So if somebody destroyed absentee ballot, which I think that's been alleged in Pennsylvania, I haven't heard it alleged elsewhere, then that would be seriously problematic.
Okay, interesting. And Civil Service says Rudy Giuliani is bringing a suit for election fraud. He must be bored with the laptop forensics. Another thing we've been hearing in the media is Trump is out of money. That's why he's hiring Giuliani. Am I wrong in thinking he's hiring Giuliani because some of his lawyers are quitting because of the public pressure?
I think what's publicly known about that is he's always had great confidence in Rudy Giuliani. And that's because he grew up in New York. So Rudy grew up as the hero lawyer of New York, the U.S. attorney who put away the mob, who figured out RICO, who went after all the corrupt criminals, who was unafraid, became mayor, very popular mayor of New York. I think Time Magazine had a front cover, America's Mayor. So that's who he knows as Rudy Giuliani. So I think that's why he has confidence in Rudy. And clearly, like all the Hunter Biden related issues, he had confidence in Rudy. Rudy was under consideration for the attorney general position before it went to Sessions. Trump probably wishes he did do that. But I think that's where his confidence comes from. So I know there's been a lot of criticism of Rudy. It's fascinating to hear that criticism from media circles that celebrated him just a few years ago, including when he ran for president in 2008 on the Republican ticket. So there's a friend of mine that's a high-ranking person at CNN now who was one of his key campaign people in 2008 who had very different things to say then And now, just because Giuliani defends the president and raises serious issues about this election, that again can be easily resolved with 90% of them, not all of them, but 90% of the issues can be easily resolved with an honest recount that's monitored and observed, and an honest signature match that's independently confirmed by observers. The fact, to me, they want to talk about, hey, where's the proof of all the fraud when we have the exclusive access to that proof anyway? My view is real easy. Just do a signature check if no fraud occurred. You wouldn't be afraid of it unless you're worried about something in that signature check. And
it would be the easiest and most cost-effective to do, I would imagine. And if there's
Absolutely.
no, it would certainly say, look, there's no issues on where the most likely irregularity would have occurred, so we don't need to go further. Someone had just asked another question that I wanted to get before we end. Oh, son of a beasting. Hit the like button, y'all, was not the question. It was. Let's just see if I can't find it in 30 seconds. There's an F Trump here. We don't need to we'd see that. Oh, cripe. Okay, I think I've forgotten it. Okay.
I mean, I know there was a question about SCOTUS. I think the Supreme Court will issue a decision of some type, but you can tell that they're trying to bide their time and hope not to be involved. Because they could have, they should have taken protective action before the election. And they could have probably avoided a large amount of this. Particularly if intermingling of ballots occurred in Pennsylvania between ballots that arrived on time, ballots that didn't. If that's a contested issue of fact, but we'll never, at this point, it'll be hard to know what the truth is. So it's again, the reason why we have independent monitors at each aspect of these vote counting processes, including the vote gathering process, including the vote ballot receipt process, is precisely to avoid a he said, she said situation after the election. In my view, the evidentiary inference should be, if you fail to allow observers, it presumes you did something bad. Just like the rule is in court, if you hide or destroy evidence, every negative inference can be given to the jury as to what they can conclude that evidence would have shown. I think that's partially Rudy's argument in Pennsylvania and Michigan, but particularly Pennsylvania, is that the hundreds of thousands of ballots were counted without observers when observers were entitled to be there under Pennsylvania law. They call them watchers under Pennsylvania law. The inference should be that those ballots were illicitly, should not have been counted because of that exclusion of observers. If we don't enforce any remedy for the exclusion of observers, then in the future, all you're going to do is kick out the observers. You don't have to be like Fulton County and pretend something broke in the sink, to come up with some pretext to delay opening. You can come up with other pretexts like, hey, you go home now. We're all going to sleep. You don't have to worry about it. Like the other pretext Fulton County came up with. So, and we're supposed to trust these election officials when they're doing stuff like that. So put it this way: if the roles were reversed and these were Texas Republican counties that did this for Trump, you can guarantee the press coverage would be a lot different.
No question about that. Now, Patrick, there was a question earlier about the audit can be ordered by court. It can be, depending on the state. Patrick Kennedy says, heard Georgia recount observers 1 per 10 tables, each 6 feet apart. Can this be remedied only through a canvass audit after the fact?
It wasn't what I can discuss is what's been publicly disclosed. There was a letter written by the Georgia Republican Party that said that was not the original agreement the Secretary of State had agreed to, and that they requested he modify that. That may have happened over the weekend. I do not have personal knowledge one way or the other. My concern is that the right way to do a recount. We have all these best practices procedures. They should have put out an instruction guide, given notice in each county. Hey, to make sure you can have your monitors present. The monitors need to be able to see the ballots, because otherwise, what's the point of the monitors being there? The monitors are not there to be like, oh, that person is picking a piece of paper up, saying something, and putting it over there. That's not why the monitors are there. And yet, that appears to maybe what has happened in Georgia. And so, again, I don't understand why there's this massive effort by election officials and the press to not have an honest count. If there's no fraud, let's have an honest count. There's nothing to be afraid of. I'm deeply disturbed by the big course of behavior by the states and by the press in attempting to gaslight and gatekeep in such a way that an independently observed. This election would never meet our own standards for an election in a foreign nation.
That's it. That's the best way to put it. Now I'm going to get the last three comments. This one's material. Greg Marquez says, just because you weren't registered for the general election doesn't mean you can't vote in the U.S. Senate runoffs in Georgia.
He's partially correct. So the concern is, so you have to have been able to be registered to vote prior to the general election to be able to register to vote in the Senate runoff. The concern is that people will move in, claim they lived in Georgia 90 days ago, and then register to vote. That would be a crime, however. So they should be quite careful of doing that.
Okay, and that's the distinction, is that they registered or not for the original election, they had to have been able to be susceptible of registration, even if they weren't. So people moving in now would not meet that criteria, and that might be irregularities. Okay, the last question was, the second to last question. What's the best way to check if our ballot has been counted and not thrown out or destroyed? Is there a way to do that?
It depends on the state. I believe in Georgia, for example, the Secretary of State has a My Vote page, and you can put in your name and see whether you voted. And so different states are supposed to have that. So it depends on the state. But if you Google it, you can find it. It will usually show up on the Secretary of State's page, sometimes the local election counties officials page. But that's how, for example, actually Richard Barris has access to other things, the People's Pundit. Yes, there is a way for you to confirm that your vote did in fact count, and you can check to see whether somebody voted for you by mail or something like that too. Okay. See whether somehow there's two votes for you.
Okay, and last question I'm not taking up any more here. I'm going to bring these out. Last question. A few people asked RICO lawsuits for this type of election issues. I mean, I think I know roughly the idea, but RICO, it's a hopeless wish.
I mean, really, racketeering is when an individual uses a business or an enterprise or association to commit specific crimes like embezzlement, extortion, things like that. It was meant to get at the mob in particular. So it can potentially cover something like this, but it's generally difficult. And what I would say is this: if the courts are unwilling to meet an election contest or equal protection statute, you can guess what their reaction will be to a RICO claim. So I don't think it will provide an effective remedy as people would like. But I'm going to look at all the options and alternatives and ways to bring legal action. Even if nobody ever does anything and it ends up the way some people think it will, I believe that there's ways to find ways to remedy the system effectively over time, or at least keep fighting to do so.
All right. You know what? I actually forgot. People will be very angry. Any updates in Rittenhouse? Totally separate subject.
Not to my knowledge. I believe they're raising money for bail. I don't believe he's been granted bail as far as I know, but I will confess I've been immersed down here about 16, 18 hours. It's been long days.
I can't imagine. I mean, I was very happy that you still had the time to do this, because it's just, I know what you're doing and it's madness. So, okay. And on that note, we're going to end it on the madness, because I suspect you're not going to bed now. So there's going to be news coming this week. Next week is Thanksgiving in America.
It is the 25th. Though some governors, and I think there will be more lockdown lawsuits. Obviously, the governor of Michigan is back to saying no Thanksgiving. Other people are saying no Thanksgiving. Some people are saying no Christmas. This is insane. Once I get through all of this, that will be the next thing I turn to in terms of public interest area legal actions.
Can you just? Look, I say this as an outsider observer. They're saying this. People were just in the streets with the blessings of mayors, celebrating as I think they probably should have the right to do, with mayors on bullhorns, with Schumer dancing in the streets, now telling people they can't celebrate Thanksgiving with their family. It's enraging, and that is as non-law as I'll get for the evening. Okay, so we'll see. We'll figure it out. If we don't do a next Sunday night stream for Thanksgiving, we'll figure it out. But people, don't despair. We will be back. If it's not a midweek, we'll figure it out, and you'll all get notification. Thank you all for tuning in. It was another 16,000 tonight. Beautiful. I love it, and everybody's having a good chat in the chat section, and there's some heated chat, but that's what it is. Thank you all for tuning. Thank you for the support, Robert. Thank you as always. What do you want to end with? And stick around for our proper goodbye. What do you want to say?
Yeah. And I will be over at, and I will be checking in daily at the Viva Barnes Law .locals.com site for people in providing. I had originally intended to provide more content that just got a little bit delayed, but ultimately we'll have book reviews and movie reviews and other things. I even have it all set up. I even got my little Hobbit pipe ready. I got my by my leather chair by the fireplace to give people all this. I just had to hop on a plane because somebody asked me to come someplace. So, and given who it was, I couldn't say no.
Amazing. Well, we're all eagerly following the news for any updates, and as soon as I have any, they'll be on Twitter and when they're public. So everyone, thank you very much. Enjoy what's left of the weekend, and